Good afternoon and welcome back to the Public Service Commission of South Carolina. We are continuing with the hearing in docket 2022-188-EC. Parties are present. Let's take a roll call of commissioners. With us virtually, we have Commissioner Irvin, and present in the hearing room, we have Commissioner J. Williams, Vice Chair Powers, Commissioner Thomas, Commissioner C. Williams, Commissioner Caston, and Chair Belser. We'll recognize Mr. Ellaby for your next witness.
Thank you, Madam Chair, and we appreciate again Commission's willingness to have Mr. Booth testify remotely. Mr. Booth, I can't see you, but are you there?
They're going to bring him up.
Okay.
I am.
And before you begin, let me go ahead and swear the witness in, if you don't mind.
And Madam Chair, might I observe that I trust that our summary this time is going to be a summary?
Mr. Willoughby, we've had numerous instances where people go through their summary with a Q&A. So,
Well, we have, but we
limit it to the pre-file testimony.
limit it to the pre-file, and if we're going to read parts of it, might as well do a traditional summary. But I just want to make that observation.
Mr. Booth, thank you, Mr. Booth. You've got your right hand raised. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Mr. Booth. Mr. Ellaby, and let's realize that there is a slight delay when we have somebody virtually.
Thank you, Madam Chair. Mr. Booth, would you state your name for the record, please?
Gregory Lee Booth.
And by whom are you employed, Mr. Booth?
Gregory L. Booth, PLLC.
And Mr. Booth, have you caused to be prepared or prepared yourself 41 pages of direct testimony that's been pre-filed in this docket?
Yes.
If I were to ask you the questions contained in that direct testimony today, would your answers be the same?
Yes.
Madam Chair, we'd ask that Mr. Booth's direct testimony be copied in the record as if given from the stand.
Mr. Booth's direct pre-file testimony will be entered into the record as if testified to from the stand.
And Mr. Booth, did you attach 7 exhibits to your direct testimony?
Yes.
And those exhibits are identified and described in your direct testimony. Is that right, sir?
Yes.
Madam Chair, we would ask that Mr. Booth's 7 exhibits be entered into the record as the next hearing exhibit.
Mr. Booth's 7 exhibits that were attached to his pre-file direct testimony will be marked for identification as hearing exhibit number 8 and received into the evidence of this case.
Mr. Booth, have you also caused to be prepared 12 pages of surrebuttal testimony that's been pre-filed in this document?
Yes.
If I were to ask you the questions contained in your surrebuttal testimony, would your answers be the same?
Yes, they would.
Madam Chair, we'd ask that Mr. Booth's surrebuttal testimony be copied in the record as if given orally from the stand.
Mr. Booth's pre-filed surrebuttal testimony will be entered into the record as if given from the stand.
Mr. Booth, would you summarize your direct testimony for the commission, please?
Yes. Good afternoon, commissioners and chair. I'll give you a very, very brief overview of my 55 years of experience in engineering services to electric and communication utilities. I have a Bachelor of Science degree in electrical engineering from North Carolina State University. I'm a registered professional engineer in 23 states, including South Carolina and the District of Columbia. I have an OSHA certification and have maintained that for decades. and have served on numerous OSHA safety committees, including for one of the large national electric utilities. Basically, I had planned, designed, and provided construction management for virtually everything an electric utility does, with the exception of a nuclear power plant and a coal-fired plant. I've designed thousands of miles of utility lines using the NESC and accepted utility practices. I've performed hundreds, if not thousands, of power line and joint use pole operation and maintenance, work order inspections and assessments, and putting that information into the National Joint Use Notification System. I've testified before 15 regulatory commissions on numerous occasions, the Federal Energy Regulatory Commission, in 34 state and federal court jurisdictions, including on many communication attachment issues and accidents. I have personal experience with over 35 incidences in which communication facilities cause serious personal injury or death. I have performed hundreds of arc flash studies. I support York's pole attachment standards requirement for the communication conductor's vertical clearance above ground of 18 feet. This is essential considering communication companies, including Charter, do not typically have professional engineers design their installations. Additionally, the final sag is always greater than the initial sag. You also have ice loading, which creates greater sag and brings the conductors down, in some cases, several feet. York's requirement is mandatory to have reasonable opportunity for the communication lines not to fall below the 15.5 foot minimum vertical clearance above ground. I support the York pole attachment standards requirements for the communication clearance from the York neutral to be no less than 84 inches. First and foremost, it is necessary to protect the communication worker from the hazards of York's 25 kV system and the arc flash event and the extensive heating that comes from an arc flash event. The hazard of arc flash events to a communication worker is actually greater than to an electric utility worker because the communication worker doesn't have the benefit of the reclosers being set on non-reclose or one shot, and then to have the fast interruption speed. Second, providing this space provides for a much greater, safe, efficient, and timely electric service to the member consumers. Third, in order to avoid unnecessary delays because Charter's failure to move its facilities, relocate its facilities, or pay for make-ready work, this allows the Electric Cooperative York to deliver its service to its member consumers when new service is requested in the expected timely fashion. York standards are necessary to provide safe, reliable, and affordable electric service to its member consumers while providing the protection for the communication worker and the public. The York clearance requirements are not inconsistent or in violation of the National Electrical Safety Code. The National Electrical Safety Code establishes in many instances not less than standards, and it provides for Rule 12, which is the good utility practice given local conditions which allows the pole owner to impose additional requirements in the application of all of the rules, not just a few, of the National Electrical Safety Code.
Mr. Booth, did that conclude your summary of your direct testimony?
It does.
Would you summarize your rebuttal testimony for the commission, please, sir?
I will. The purpose of my rebuttal testimony was to address and rebut Mr. Bingle's rebuttal testimony, including his errors in the use of Mr. Laponi's information on Comporium. The Comporium practice and a cooperative or electric utility practice of putting fiber optic cables in the electric utility space is common practice across the country and with electric utilities. Mr. Bingle testified that charter must be fully compliant with the National Electrical Safety Code. Yet, Mr. Bingle and charter want this commission to cherry pick a few items from the NESC and disregard all the other National Electrical Safety Code rules and portions of rules, such as ignore the not less than language, consider 15.5 feet as a maximum vertical clearance when the line's installed, and ignore final sag being greater than initial sag and ice loading, pulling that line down lower than 15.5 feet. Together with, the line has to consider other areas and vehicles traversing under it, causing the line to have to be significantly higher than 15.5 feet. Charter has, to my knowledge, throughout decades, no inspection of the initial installation of its lines for the compliance with the National Electrical Safety Code. That's required by Rule 214 of the NESC. They've already testified that it sounds like they're expecting York to do this inspection for them. That's inconsistent with the National Electrical Safety Code, and it's certainly inappropriate. They want us to ignore the arc flash hazard and assessment requirements of the NESC and of OSHA, and most particularly NESC Rule 410. Arc flash for an electric worker has non-reclosing reclosers and fast curves, driving the arc flash incident energy level and its associated heat down because keeping the arc of a very short duration. Communication workers don't have that one-shot non-reclose fast curve feature because the electric utility can't set the device on non-reclose because they don't even know the communication workers that are out there. Think about, just quickly think about this as a 500-degree oven with the door open. The longer the door is open, the more that heat comes out of the room and can burn you. The same thing's true of an arc flash. The arc flash, and the longer the duration of the arc flash, the greater the distance of the heat. That's what my calculations are all about. Additionally, the code very specifically in the very beginning states this code is not intended as a design specification or an instruction manual. Mr. Bingle says NESC creates uniformity among utilities. It does not, absolutely. Investor-owned utilities, electric co-ops, electric municipalities, their designs are different in many, many ways. And in fact, most utilities have many different designs within their same utility system. As an example, which is very important to this particular proceeding, Duke Energy, for instance, places its neutral at the bottom of its transformer tank for its distribution transformers serving residential customers. York and rural utility service standards for some 900 co-ops across the country had the neutral at the top of the tank. That not only has a major impact on the communication worker safety zone here issue and clearance issues, but it also has a major impact on minimum approach distances and major impacts on arc flash, because the bushing of the transformer is only, which is energized, and the energized top of it, which is then connected to the primary line, is only inches away from that neutral position. York uses professional engineers to design all of its facilities in a rigorous post-construction inspection process, including having professional engineers certified to those inspections. Charter doesn't do anything like that. Communication lines owned, installed, and operated by York, the fiber we talked about for Comporium, is located in the electric supply space, and it's in full compliance with the National Electrical Safety Code. It does not adversely impact the communication worker safety zone. If necessary, those facilities could be moved up on the pole to make more room for communication companies. And most importantly, the workers that work on those facilities are qualified electric utility workers, qualified to work on energized electric utility lines. They're not communication workers, which have to keep 36 inches of minimum approach distance away from energized lines or facilities. Arc flash injuries, low communication lines are a major problem across the United States with communication lines and companies like Charter in general. In just most recent times, on my testimony, I have some 35 injury cases where communication workers were either seriously injured or killed by arc flash, and where low communication lines resulted in serious injury or death to public. Mr. Bingle says communication workers are adequately trained. In my over 50 years working in the communication industry, I've designed many of their facilities as well. I have never found a communication worker, particularly cable worker, trained on the National Electrical Safety Code. In court cases, these workers most often testify that they either are not trained in the NESC or don't even know what the NESC is. Charter and other communication companies, in all these cases I've been in, haven't been able to produce National Electrical Safety Code training materials they've used for their workers. York and other electric utility workers, my experience have extensive experience in the training of the NESC. The 40 inches in table 235-5 is for up to 8.7 kV. York is also building out a 25 kV system, which has 14.4 kV to ground. And the transformer bushing is nearly at the neutral position height. So you have to use the adders in the NESC, which Mr. Bingle and Charter want to ignore. Bingle seems to be also disregarding OSHA requirements, which require arc flash hazard assessment and protections when one is working on or near electric utility facilities. And communication workers do work near those facilities, because anything inside of the OSHA 10-foot rule in working, which is where a communication worker is, means they're working near energized electric utility facilities. York's 84 inches from the neutral and 18 feet vertical clearance is essential for safety of employees, the public, and the system and reliability. In my testimony, I have not been using jargon or scare tactics. I'm using over 55 years of planning, design, and construction management experience with the NESC, with OSHA, and accepted good utility practice, particularly given local conditions. That's the end of my rebuttal summary.
Thank you, Mr. Booth. Please answer any questions that council or the commissioners have for you.
Mr. Willoughby or Mr. Warner?
Yes, Madam Chair. We have some questions.
I need for you to turn your. Thank you. Well, it's not on yet. No, sir. Now it's on.
Okay. I have one procedural question, or technical question. If I put something on the almos, are you gonna be able to see it?
Yes, they can make sure. It just give us a second to adjust things, and please realize there's a little delay. There might be a little delay between your question and it transmitting to him and his answer getting back.
Okay.
Slight.
Try to slow down. Mr. Booth, are you out there somewhere? All right, there you go.
I am.
Mr. Booth, it's good to see you again.
Good to see you.
I was hoping that we could do this live this time,
Wish we had.
but I appreciate you need to be at home, and I hope your wife is okay.
It's quite a challenge.
I can understand. Mr. Booth, in your testimony and your resume, you state that you have experience in the area of electric utility and telecommunications engineering. Is that right?
Yes,
Okay. And I'm correct that you're not a lawyer, right?
I am not.
Okay. So you're not here to offer the commission any legal opinions, are you?
I am not.
Okay. And am I correct that the purpose of your testimony submitted in this proceeding is not based on any experience or expertise in promoting broadband deployment?
I have extensive experience in that. I have many clients for which I assisted them in obtaining the financing, doing the design of broadband for extension to rural areas and unserved and underserved areas. So I have extensive broadband experience.
Mr. Booth, the purpose of your testimony in connection with this proceeding, however, is not in connection with promoting broadband deployment, is it?
No, it is answering the questions and issues directly associated with the Charter Spectrum petition.
Right. What I'm getting at is, I just want to be clear about this. Your testimony in this proceeding is not to offer opinions on the impact of York's practices on promoting broadband deployment, right?
That my pre-filed has not been, but if I'm asked questions about it, I have extensive experience in that area with many electric utilities and would answer the questions.
Okay, fair enough. I just want to make clear that those matters aren't addressed in your pre-filed testimony, right?
They are not.
Okay. As I understand it, your testimony instead is in support of York's clearance requirements, right?
Yes, combined with York applying all of the National Electrical Safety Code and York having the right to require the applications to include professional engineering designs.
Yeah, yes, sir. But just to be clear, there are two specific clearance requirements that are actually at issue in this proceeding, correct?
Yes,
Okay, and one has to do with the midspan clearance, right?
correct.
And the other has to do with the 84-inch separation requirement, right?
The separation, the communication worker safety zone separating the electric supply space from the communication space.
Okay, and we're going to get into this, but the communications worker safety zone as reflected in the NESC is 40 inches, correct?
No, it is not less than 40 inches up to 8.7 kV. There are many other factors that have to be considered. 40 inches is not a absolute.
For the increased voltage, the communications safety worker safety zone is actually 43 inches, right?
Again, using the calculation in the table, but then you also have to take into other work rule considerations, including arc flash hazards.
I understand, sir, that we're going to be speaking about your arc flash zone in a bit. I just want to make sure that we're on the same page. And putting aside labels, the separation at issue in this proceeding is 84 inches, right?
That is correct.
Okay. And to be clear, you, Mr. Booth, were not involved in the creation of either of those standards by York, right?
That is correct.
Okay. So when York adopted those, whenever it did not consult with you before it did so, correct?
It did not.
Right. And so the justifications that you offer in your testimony are all after the fact justifications, right?
No, they're my justifications that would have applied to York's decision, consistent with both South Carolina and other jurisdictions like Georgia and Virginia and the like. North
Sure.
Carolina.
I'm sorry. Mr. Booth, my point is that you are evaluating those standards after York had already adopted and implemented them, correct?
That's correct under the dispute in this petition.
Right. Now, at the outset of your testimony, you discuss what, in your opinion, are typical characteristics of South Carolina Electric Cooperative Pole Plant, right?
Yes.
Okay. What did you do? What did you, Mr. Booth, do in preparing your testimony to come up with what are the typical characteristics of South Carolina Electric Cooperative Pole Plant?
Probably 30 plus years of providing engineering services in South Carolina, including the South Carolina Electric Cooperatives.
Did you ride out any of York's plant?
Not immediately preceding this, but I've been across the preponderance of electric co-op plant in South Carolina throughout my career.
Sir, my question is in connection with preparing your testimony, did you write out any of York's plant? And I believe I understand your answer to be no.
Not immediately before it, but I have seen York's plant and many of the other electric co-ops plant in my career.
Okay.
Working in South Carolina.
And Mr. Booth,
It didn't see the need to do that right out again.
okay. Mr. Booth, you offer a diagram in your testimony that reflects a 40-foot pole as a typical pole, is that right?
Yes, that's a 40-foot tangent straight line pole, 3-phase with a District 1 residential distribution transformer.
Okay. And you understand as well that York has 35-foot poles in its system?
Yes, they've got 30-foot poles, 35, 45, 50, 55, yes, a whole variety of pole heights.
Okay. I want to talk to you a bit about the NESC. You don't hold a position with the NESC, do you, sir?
I am not on any of their committees. I have spent decades working with the previous chairman, Alan Clapp, and I have taught many NESC courses that have been accepted in the states that I've taught them and by professional engineering boards.
Mr. Booth, you're not part of the NESC Rules Committee, are you, sir?
I am not.
Okay, and you're also not part of any of the NESC working groups, are you?
I am not.
Okay. And I'm correct in understanding that you actually haven't authored any part of the NESC or any part of the NESC handbook, have you?
I have not. I have caused new rules that come into play with questions that I've asked the code committees over the years, including space for antennas and other things like that. So I have been involved in assisting through the processes with the code committees for additions to the code.
Did you ever ask the NESC to expand the communications worker safety zone, sir?
I have not. It wasn't necessary because the code provides for it.
Mr. Booth, your resume notes that you're an associate member of the National Rural Electric Cooperative Association Advisory Committee. Is that right?
I was for many years. I'm not now.
Okay. And I'm correct in understanding that the NRECA are members, York and other South Carolina electric cooperatives are members of the NRECA, right?
Yes.
Okay. On your resume, you know you're a member of that organization's advisory committee. Are you no longer part of that?
Not any longer.
Okay. Are you aware that the NRECA is a member of the NESC subcommittees?
Yes, I am.
Okay. So you'd agree with me that through the NRECA, York and other South Carolina electric cooperatives have been actively represented and involved in development and revisions to the NESC?
Yes.
Okay. So if they ever were dissatisfied with provisions in the NESC, they could propose changes, right?
Correct.
And that would include changes to the NESC's clearance requirements, right?
Correct.
Okay. Now, in your summary and also in your pre-file testimony, you refer to the NESC as providing minimum clearance requirements, right?
In South Carolina, that's one of the good accepted utility practices. My summary said not less than. My testimony said not less than, other than the reference to South Carolina.
Well, when you say the reference to South Carolina, you're referring to a rule of of this commission. Is that right?
That's correct, and that's at least one good accepted utility practice in the state of South Carolina, and the code provides for utilization of those.
Okay, just focusing your attention on the commission rule. Do you understand that that rule doesn't apply to cooperatives like York Electric?
I don't agree with you on that. So the rule doesn't apply as a matter of commission law, but the rule does apply as a matter of looking at accepted good utility practice.
But you agree the rule doesn't apply as a matter of commission rules and regulations, right?
I agree with that.
All right, and what you're saying is just as a good utility practice in your mind, you think it should apply.
In the state of South Carolina, yes.
You say in the state of South Carolina, under what authority are you referring to?
That is a rule at the South Carolina Public Service Commission. So that establishes the minimum, the code clearances as minimum, as a good accepted utility practice in the state of South Carolina.
Sir, but I thought you just agreed with me that that rule doesn't apply to cooperatives like York.
I didn't say that. What I said is it doesn't apply as part of the commission regulations, but it's an accepted good utility practice, and under the NESC Rule 12, that's something you would consider in the state of South Carolina.
Okay, you'd agree with me that Section 23 of the NESC, and specifically Rules 232, 235, and 238, as well as their respective tables, those define the relevant vertical and mid-span clearances for overhead communications lines, right?
Yes, under a variety of conditions, including a whole series of design requirements.
Okay. Now, the commission rule that you refer to, 103-361, are you aware that that was last amended in 2008?
Yes, I am.
Okay.
I've testified in court cases in South Carolina relative to that.
Okay, and you'd agree with me that the South Carolina legislature enacted the Broadband Accessibility Act in 2020, right?
Yes,
All right. And the Broadband Accessibility Act does, in fact, apply to electric cooperatives like York, right?
correct.
All right. And you'd agree with me that the Broadband Accessibility Act, or we've been referring to it as the BAA, does not refer to the NESC as minimum standards, does it?
It doesn't refer to it as minimum or maximums. It just says use the NESC.
Okay.
And considering that the commission's rule says minimum, and that act applies to people that are, or utilities that are regulated by the commission, it would be my engineering position that minimum applies to all the clearances in the NESC as it would relate to the Broadband Act.
Are you offering a engineering position or a legal position as to the impact of the commission's rules as it relate to the BAA?
That's an engineering position, because if it says, if an act says apply the NESC, and you've got a commission rule that says the NESC is a minimum, and that act applies to utilities like Duke that are regulated, then from an engineering standpoint, I would expect that the minimum is applicable to the NESC in the state of South Carolina, including for the act.
Okay, so in your opinion, you're reading the commission rule, which doesn't apply to York, to actually apply to York through the NESC, irrespective of what the BAA actually says. Is that right?
No, I think I explained what I'm saying, and what I'm saying is the BAA isn't disregarding the law or what the commission has adopted. It applies to utilities that are regulated by the commission. So by sheer definition, the NESC Part 2 in particular in South Carolina is considered a minimum. So when a new act or law comes in, I don't see the necessity to insert the word minimum in that when you already have something that says minimum.
Right.
Already defined.
Okay, so the commission rule that we're talking about, it refers to Part 2 of the NESC, correct?
That's correct.
And it does not refer to Part 4 of the NESC, correct?
It does not, and probably doesn't have to, because OSHA takes care of all the Part 4 issues anyhow, but that still doesn't mean you ignore Part 4 of the NESC.
Well, the rule doesn't refer to it at all, does it?
No, it does
Okay,
not.
thank you.
It doesn't refer to Part 4 at all. It refers to Part 2.
Okay, let's talk a bit about your opinions. You assert that York's clearance requirements are justified because of your views about the condition of communications provider attachments and training. Is that right?
Among many other things.
Okay, I want to focus you in just on that one aspect of your opinions. And it's your opinion that cable companies don't routinely comply with safety requirements and standards. Is that correct?
No, what I'm saying is that the employees aren't trained on the NESC, and relative to NESC issues like clearance between facilities or height of lines over the roads are often not complied with by the construction workers.
Okay. And let me ask you this. You don't actually have any firsthand knowledge of the oversight that Charter exercises over its contractors in South Carolina, do you?
I do, by virtue of the numerous cases I've had involving Charter in which they have described their Southeast oversight, what they do, how they inspect, what teachings they have. I've had this in court cases and regulatory cases many times, and I have a very good understanding of what they do and don't do. I've identified hundreds and if not thousands of their violations, and determined that they don't do an initial inspection after post construction.
Sir,
And they don't teach the NESC to their workers, and the communication contractors aren't taught the NESC.
sir, in your direct testimony and in your sir rebuttal testimony, you don't attach any documentation or evidence of a single specific example of allegedly poor attachment engineering or training by Charter or its contractors, do you?
I would disagree with that because I believe in my attachments in my resume, I include cases which I have testified on that are just such cases.
So,
And I discussed that in
you're
my
off.
summary.
I'm sorry. Are you finished?
Yes,
Okay, so you're pointing to your CV, is that right?
yes,
And you're asking the commission to rely on your CV as evidence of Charter's training and construction practices, is that right?
and my sworn testimony here.
Okay. You didn't provide any photos in your testimony of any engineering or training issues by Charter, did you?
I did not. I could provide hundreds of those if necessary.
Have you ever sat down with anybody at Charter to go over how they train their workers and contractors about the NESC?
Yes,
Have you reviewed Charter's contracts with its contractors?
yes.
In what context?
Court cases, regulatory cases.
Okay, and these are cases of which you did not provide any actual evidence in your testimony, did you?
I did not. I thought my testimony was sufficient.
Okay. And in connection with this proceeding, am I right that you didn't actually perform any investigation of Charter's actual practices with respect to York's polls, correct?
Only to the extent that I had conferences with the York Engineering and Management.
Okay, and you didn't talk to anybody at Charter in connection with your testimony, did you?
I did not.
Okay, and I'm correct, aren't I, that you did not prepare or submit any report of any investigation that you performed of any poll conditions that you actually discuss in your testimony, correct?
That's correct.
Okay. And so, for instance, you didn't provide or even prepare in connection with your testimony any study of the rate at which communications providers versus utilities in South Carolina create or are responsible for non-compliant poll conditions, right?
I have no study to that, correct?
Okay, right. And let me ask you this. You discussed that communications workers should be trained on the NESC. You would agree with me, though, that they don't need to be trained to work in the electrical space, right?
I would agree with that, yes.
Because they're working in the communications space, correct?
That's correct, with uninsulated buckets, uninsulated equipment. That is correct.
Because if they were trained fully on the NESC, they'd be qualified to work in the electrical space, correct?
No,
No?
they would have to go through lineman career training. They would have to work their way up through a lineman career training process. Teaching the NASC is teaching the clearances and the code and the issues relative to construction for communication or electric workers. That doesn't qualify a person to be an electric utility lineman.
Right, but you'd agree with me that communications workers don't need to have all of that training, correct?
That they do not need to be trained to work in the electric utility space.
Because if they were, then there'd be no need for a communications worker safety zone, correct?
Yeah, that's correct. They would treat their facilities the same as York treats its fiber in the electric utility space, because all the work is being done by qualified electric utility workers.
Right, because the whole point of the communications worker safety zone is to protect communications workers who are not trained to work in the electrical space, right?
Yes, that's correct.
Do you know how many attachments Charter has on York's poles?
I do not.
Do you know how many communications attachments total are on York's poles?
I do not.
And I'm correct, aren't I, that you didn't conduct any statistical analysis of how often Charter's attachments are out of compliance with the NAC on York's poles?
I did not.
Or even count up how many of Charter's attachments are out of compliance at all, right?
I have not. York has done that work.
I'm right that you didn't conduct any field audit of Charter's attachments in connection with your testimony, correct?
Not on York's system.
Okay. Now, you'd agree with me that attachments can fall out of compliance for a variety of reasons, correct?
Yes,
Natural causes like weather, for example, right?
that's correct.
Changes in the built environment would be another, right?
Rephrase that. I'm not sure what you mean by that.
Well, for example, if a field is converted to a strip mall or something like that, it would change the environment and potentially change the required rules, right?
Well, absolutely. If you have a cultivated field that's now being planted with cotton and cotton pickers are being used, that's a significant change in the environment the line crosses.
Okay, and you'd agree with me that actions of other attachers, including the pole owner, can also cause attachments to fall out of compliance, right?
That's a possibility.
Okay, and vehicle accidents could be another, right?
Correct. If the vehicle hits a pole, it brings the pole down out of compliance.
Okay, and you'd agree with me that in light of all the factors that can work on the pole environment, that it's often difficult to determine what or who actually caused any given non-compliant pole condition?
No, I wouldn't agree with that.
You're-
I've had no difficulty establishing which party or what outside force was responsible for the non-compliance.
Okay, but just to be clear, you didn't perform any of that kind of analysis in connection with your testimony before the commission, right?
Well, I've done that analysis thousands of times for electric co-ops and electric utilities. So I didn't need to go do a special one here.
Okay, and you did not do a special one here, right?
I didn't do a special one on the York system because
Okay.
I've got experience with thousands of circumstances right up to just, a few months ago.
All right. You'd agree with me that pole owners are required under the NESC to maintain their facilities in compliance with the code, right?
Yes,
All right. Now, you talk about a lot of different situations where you're evaluating injury cases or other kinds of personal injury matters, things like that, right, in your testimony?
yes,
Okay. Now, when you're engaged to review one of those instances, do you actually go out and visit the location to review the pole conditions?
yes,
Do you perform an analysis to support your conclusions when you evaluate those kinds of occasions?
Yes.
Okay. Is that a written analysis?
Most of the time, it's a written report. It'll be deposition testimony, trial testimony, exhibits.
Do you review utility records to determine how conditions came to exist in those cases?
Yes.
Okay. Now,
And,
you
and
test.
I review all the circumstances surrounding any given accident, whether it's a communication worker being blown off a utility pole by an arc flash, or a truck hitting a low communication line and decapitating a poor public person in a parking lot. You know, I investigate all the details behind all of that.
Okay, terrific. When a pole attachment falls out of compliance, you testify they can create risk to public safety, right?
Correct.
So you'd agree with me that whoever discovers a condition like that should report them right away to the communications provider if the communications provider line is at issue and the party that's responsible for the condition, right?
Yes.
Okay. Have you looked at the pole attachment agreement between York and Charter that was entered in 2004?
Yes.
Okay. Would you agree with me that that contract has multiple provisions for identifying and addressing non-compliant conditions?
Yes.
Okay. Would you agree with me that the NESC also recognizes that not all non-compliant conditions are a threat to human life or property?
Yes.
Okay. And those kinds of conditions, ones that do not involve risk to human life or property, under the NESC just need to be recorded and corrected as time permits, right?
That's correct. So it's those that will be a risk to property or the public that have to be isolated or remedied immediately.
Okay. Do you know how often York has contacted Charter about non-compliant conditions?
No.
All right. Let's talk about the 84-inch, what I think you refer to as the 84-inch communication worker safety zone. You would agree with me, Mr. Booth, that the purpose of the communications worker safety zone is, just as it implies, it's to ensure the safety of communications workers, right?
That's correct, but let me correct one thing. We're not talking about an 84-inch communication worker safety zone. We're talking about the clearance between York's neutral and the communication attachment being 84 inches. So if you place a transformer or other equipment on the pole, the communication worker safety zone could be as little as 40 or 43 inches.
Okay. That's actually what's provided in the NESC in Table 235-5, right?
That's the not less than in 235-5.
Right. The communications worker safety zone is a concept that is expressly addressed in the NESC, right?
It is.
Right. And it's addressed specifically in the table of the NESC 235-5, right?
No, and that's part of the disconnect that Charter and Bingle and I have. You want to pick one number out of a table and ignore all the other issues that have to be taken into consideration in the NESC. It's a complete document. It's not just one number from a table.
Sir, we're going to get into your discussions of the arc flash zone and so on. But you would agree with me that the thing that is called the communications worker safety zone is identified and established in Table 235-5 of the NESC, right?
And Rule 235 and Rule 238.
Okay, all right.
The entire Rule 235.
All right, and if you look at 235, if you look at Table 235, Rule 235 and 238, the communications worker safety zone is generally 40 inches, right?
That's the minimum or the not less than for up to 8.7 kV. Yes.
Well, actually, the communications worker safety zone can go as low as 30 inches in some cases, right?
Through joint agreement with the utility and the communication company, but obviously you couldn't be at 30 inches if your minimum approach distance under OSHA is 36 inches.
Mr. Booth, the NESC's 40-inch communications worker safety zone was first adopted in 1977, right?
That's correct, and that was decades before the arc flash hazard assessment requirements.
And you'd agree with me that that zone has never once been revised in the NESC, right?
That's correct, and it's been a minimum, and it's been a not to exceed from 77 to now,
And,
the 2023 NESC.
and you testified earlier, sir, that you've never personally requested that that safety zone be expanded, right?
I haven't, because I didn't think it was necessary, because it's listed as a not less than, and there's other provisions to consider.
In your testimony, you assert that York's increased clearance requirement is also necessary because York has designed and constructed its poles to anticipate future expansion of its electrical facilities, right?
That's correct.
You'd agree with me that that's a consideration that doesn't have anything to do with safety, right?
No, I wouldn't agree with that.
Reservation of space for future electric needs is a consideration having to do with safety. Is that your testimony, sir?
Yes, it can be, because if you're faced with a fast growing system, you've got the pressures of putting transformers up to provide temporary electrical service for construction, permanent electric service. There's enormous pressures on that. So if you don't, if Charter or anyone else is taking away your space and you can't respond rapidly enough, you wind up with the possibility of not having sufficient clearance, because transformers have to be put up to meet the demands of the customer, or in this case, the member consumer.
Did you say that?
Contract.
Sorry, sir. Did you say that in any of your pre-filed testimony?
Yeah, I think I talked about the efficiency for the co-op and the timeliness for the co-op.
Right. Efficiency and timing are not safety considerations, right?
They absolutely are. So if you have to do something in a timely and efficient fashion, you have to hurry up and put a transformer up, and somebody's taking your space away from you, and some lineman inadvertently puts it up there and creates a violation by simply trying to meet the demands of the consumer or contractor. That's a safety issue, and it creates an unsafe situation. So having adequate space to put your equipment on your pole that you originally designed for that purpose is in fact a safety issue.
So reserving space in your mind is a safety issue. Is that right?
That's one of the issues.
Okay.
Is safety.
Okay. Now, you'd agree that where a pole cannot accommodate a communications provider, then the pole needs to be replaced with a taller pole, right?
Or you have to rearrange facilities to make room for it.
Yeah, where rearrangement won't work, then the pole has to be replaced, correct?
That's correct.
And generally, in that case, the attacher would pay for the replacement costs, right?
Generally, that would be the case. So you have strength issues that you have to take into consideration because you're adding additional lines. You have to take into account clearance issues between the utilities and clearance issues over the traveled surface.
And you'd agree with me that where a pole owner reserves 84 inches on a pole, 40-foot pole, that is likely to trigger a lot of pole replacements, right? To accommodate a communications attachment.
I would not agree with that. I've got clients across the country that require 72 inches or 84 inches, and it has not triggered a lot of pole replacements.
Did you hear Mr. Bosch's testimony earlier today on that point?
Yeah, I think he was talking about out of 70,000 or 68,000, 70,000 poles, some 100 poles being replaced, that's infinitesimal.
You heard him talk about 70, 80,000 poles and only a few being replaced. Is that right?
My recollection is he said less than 100.
That was for Comporium, sir. Right?
Well, I can look at my notes, but I think the discussion was across, not just the fiber area, but the system.
Well, I think we should just accept subject to check.
Madam Chair, this is what's known as pitting the witnesses against each other and is not permitted under South Carolina practice.
Pitting is when you are challenging the veracity of witness. If you are asking the witness, do you believe what he said? So this is cross our rule.
I'll move on anyway. The testimony is what it is. You'd agree with me, Mr. Booth, that if York were just looking to reserve space for reasons like you say, time, efficiency, and so on, there's nothing magic about 84 inches, right?
Correct.
So York could reserve 100 inches.
No, I mean, York, like the Georgia Commission allowed 72 inches. So in certain jurisdictions, there's reasons for different distances. I certainly wouldn't support 100 inches.
Well, it could be more, it could be less, right? Again, there's nothing magic about 84, right?
I think there is magic about 84. It's the space needed, and it just happened to turn out that that's where the incident energy level drops below the level that requires flame retardant clothing.
That's your arc zone analysis, is that right?
Yeah, for a communication worker, not the arc zone for an electric utility worker.
Did York set the 84-inch requirement based on your arc zone analysis, sir?
I don't believe they did, because they obviously didn't, because they set the 84 inches some 20 years ago.
Right. And did you see any documents from York that support the 84 inches based on any arc flash analysis that it performed?
None.
No. And York itself has not really offered your arc flash analysis as a justification for its 84-inch requirement, right?
They're offering me as their expert on that behalf.
Sir, I'm asking that when York adopted the 84-inch requirement, it didn't do so based on any arc flash considerations, right?
I think that's a question appropriate for York, because I wasn't there in 2002 or 2004 when they made that adoption.
Yeah, and my question to you was, you haven't seen any analysis that would support the justification that is put forward at the time it did, that's based on any arc flash analysis at that time, right?
I have not.
Okay. Now let's talk about the arc flash hazard space specifically that you addressed in your testimony. Now, in your testimony and in one of your exhibits, you state that a typical pole has 6 basic sections from the top to the bottom of the pole. Is that right?
Correct.
Okay. And so there's a supply space, the communications worker safety zone, and cable space, and then you list what you call the arc flash hazard space. Is that right?
Yes, and I list the support space above ground and below ground.
Right. Now, you'd agree with me that the NESC doesn't use any terms that are anywhere close to arc flash hazard space, right?
410 does talk about the incident energy area.
Does the NESC, sir, does the NESC use the term arc flash hazard space that you do?
Not those precise words. It has the requirement for an arc flash hazard assessment using certain standards, which talk about the distances for the calculation and the space to be below 2 calories per centimeter squared of incident energy level. So yes, that is that space.
Sir, I'd really appreciate it if you just limit yourself to answering my questions. I'd really let you go on, but this is gonna take a very long time if you can't just answer my questions. And so my question
I
is
did answer.
going back to it, the NESC does not use the term arc flash hazard space, does it?
Not in the NESC, but
Okay.
if you look at the references, it does.
Okay,
You can't just look at the words in the NESC because it refers to many standards.
sir, the term arc flash hazard space, that's your term, isn't it?
That's my term pulled out of arc flash hazard assessments.
Okay.
Yes.
Have you ever asked the NESC to adopt something called the arc flash hazard space?
I have not because I don't have to because the NESC provides that in Part 4.
All right. You assert that NESC Rule 410 and the need for personal protective equipment to prevent arc flash exposure justifies York's expansion of the communications worker safety zone, right?
That's one of several supporting items.
Okay. Now, in your testimony, I just ask you about what's in your testimony. You haven't presented any evidence of any charter or communications worker being injured on a York pole because of arc flash, right?
No,
Okay. Now, Rule 410 is found in Part 4 of the NESC, right?
correct.
Okay. And you'd agree with me that that's the separate section from Part 2 of the NESC, which contains the rules on vertical clearances and the communications worker safety zone, right?
Yes.
Okay. Now, we'll get into this a bit more, but rules, I want to focus you on some specific rules. Rule 235 and Rule 238 do not mention anything called the arc flash hazard space, right?
They do not.
Okay, thank you.
That's a different part of the code, and it's also an OSHA requirement.
Okay, well, let me ask you about Rule 410. Now, that rule states that it's for employers, which apply to both electric supply and communications company employees. That's from your testimony, right? That's your representation as to what the rule says, correct?
Yes.
Okay. Now, you'd agree with me that the actual text of the rule, 410A2, says the employer shall provide training to all employees who work on or near energized lines and parts. Is that right?
Correct.
Okay. And if you look at Rule 410A3, it says the employer shall ensure that an assessment is performed to determine potential exposure to an electric arc for employees who work on or near energized lines, parts, or equipment, right?
Correct.
Okay. And so, just based on the text of the rules are designed to apply to electric workers, not communications workers, right?
That is absolutely not true. First off, Part 4 is work rules for the operation of electric supply and communication lines and equipment. So these are the rules for both companies, not just electric workers. And the on or near, both in NESC and in OSHA, communication workers are nearly always working inside of the OSHA 29 CFR 1910-333 10-foot space, which places them near energized electric facilities. And so this does apply to a communication worker.
Sir, we're going to talk about OSHA requirements, but you'd agree with me that the whole point of the communication worker safety zone is so that communications workers are not working on or near energized lines, right?
No, they're not working on them, but they're absolutely working near them. They've got a 36-inch MAD for 25 kV that's working near. If they weren't working near energized electric lines, under OSHA, under standard practices for any employee and employer, they would have to be 10 feet away with their body or anything that's conductive from the energized line. Once you go inside that 10 feet, you're now working near.
Sir, you'd agree with me that under Rule 410, arc flash calculations are performed based on an 18-inch separation distance from the arc to the employee, right?
Yes,
Okay, and you'd agree with me that 40 is more than 18, right?
absolutely,
Okay,
but I
thank you.
also agree that
You're familiar with the 2009 NESC interpretation of Rule 410, correct?
yes,
Okay, and that interpretation document says that while it is theoretically possible for an arc to occur whenever parts or equipment are energized, the likelihood, in part, is typically dependent upon the work being performed on energized facilities, right?
yes.
And you'd agree with me that communications space work is not on energized facilities, correct?
I would, but I have many arc flash incidences associated with communication workers because they're on a pole causing the pole to move around and the lines and electric facilities to move.
And sir, of those many instances of which you are familiar, you have included a total of 0 in your testimony, sir, right?
I've stated that I have 35 cases. I can certainly produce both the regulatory incident energy arc flash cases and the tort court cases, a list of them.
So, all right. Lots and lots of instances out there that you're familiar with. You haven't enlightened any of us with any evidence related to any of them in your testimony, correct?
That's correct. I
Okay,
guess you
thank
have
you.
to take my word for it.
Okay.
I'm
Let's talk a bit about the
testifying
OSHA
under
work
oath,
rules.
and I have those cases.
Okay,
Excuse me.
let's talk about the OSHA work rules. Now, you assert in your testimony that the OSHA work rules can also justify expanding the communication worker safety zone, correct?
Yes,
Okay. And you'd agree with me that when the NESC is revised, part of that process includes considering changes to the OSHA regulations, right?
yes,
Okay. And you'd agree with me again that the NESC's 40-inch communications worker safety zone has not changed at all ever since it was first implemented in the 1970s, correct?
for 8.7 kV, that's correct, but it's a not less than or minimum standard.
Right. And so if you look at footnote 4, so the NESC table 431, it states that the basis for the 3-foot minimum approach distance for communications workers was obtained from the OSHA regulations, right?
That's correct.
And an additional 1 foot was added for communications workers over the electrical work value. Is that right?
Yes,
Okay. So while electric workers can come within 2 feet of energized conductors or parts on a 25 kV system, the NESC has already added an additional 1 foot buffer for communications workers, right?
absolutely.
Okay. Let's talk about the 18-foot midspan clearance requirement and your opinions on that. You'd agree with me that NESC Rule 232 specifies clearance distances above ground, roadways, rail, and water surfaces, right?
Yes,
Okay. And those are generally what we refer to as midspan clearances, correct?
well, it's the lowest point of the conductor, which isn't necessarily midspan.
All right. Would you agree with me that NESC table 232-1 and the variety of rows 2, 3, 4 provide the specified midspan clearance from a communications cable to the ground along the span at being 15.5 feet?
But again, I'll clarify, that's not mid-span clearance. That's the lowest point of the conductor in the span. So that could be 20 feet from a pole if one pole's higher than the other.
Oh, I see what
So
you're
it's not
saying. So
midspan.
it's not, it's the lowest point. It may be technically at the midspan, or technically it could be somewhere along, but the bottom line is it's the lowest point in the span. Is that fair?
That's correct. Lowest point in the span, because for it to be the midpoint of the span, It has to be a perfectly level ground, and the attachment points on the poles have to be identical height.
Okay. And in your testimony, you assert that midspan clearances set out in NESC Rule 232 must take into account temperature and ice loading, both of which create increased sag. Is that right?
That's correct, and the final sag creep. That's correct.
And you also assert that application of NESC standards depends on geographical weather differences, different wind speeds, and local conditions, correct?
That's correct. So what you do in Rhode Island and what you do in Florida and what you do in South Carolina are all going to be different.
Okay. And in connection with your testimony in this proceeding, you did not conduct any analysis of the specific local conditions in York's service territory, right?
I wouldn't agree with that because I've performed hundreds of designs in South Carolina for co-ops, and whether it's York or any other co-op in South Carolina or municipality in South Carolina, it would be the application of the same professional engineering design standards using the NESC.
Sir, did you submit any analysis of any specific local conditions in York service territory in connection with your direct or surrebuttal testimony?
No.
Okay. So it's fair to say you actually haven't offered any evidence of any local conditions in York's service area that would warrant departing from the standard clearance requirements of the NESC, correct?
I'm actually not suggesting to deviate from the standard NESC clearance requirements. What I and York are saying is 18 feet is necessary because if contractors or charter who don't use professional engineers to design their line, don't use NESC trained contractors, install a line, measure it and say, oh gosh, look at that, it's 15 feet 7 inches, so it's fine, we can walk away. That line absolutely will not meet the 15.5-foot minimum or not less than clearance requirements of the NESC, in a relatively short period of time.
So
The initial sag is always less than the final sag, and it doesn't take, you don't sag the conductor with ice on it.
Okay, so if I understand what you're saying, you're not offering the opinion that anything in the NESC requires a deviation from what it calls for, but there are other considerations, and I'm going to get into those that prompt York to deviate from them. Is that right?
That's correct.
Okay, thank you. All right, let's talk about some of what you just said around professional engineers and so on. So in your testimony, you assert that York's 18-foot midspan requirement is reasonable because Charter does not have new installations inspected after the cables are placed in the air to assure that those attachments comply with the NESC, right?
Yes, plus they haven't done a professional engineering design to start with. They actually have a design to check post-construction.
Well, let me ask you this. York has a right and frequently performs make ready when it receives an attachment application from Charter, right?
Yes.
So when York gets an application to attach by Charter, it looks at the permit, it evaluates what make ready needs to be done, and instructs Charter how to attach its facilities, correct?
No, it doesn't do the design for Charter. It doesn't provide a professional engineering design. It says your installation has to be at least at the lowest point 18 feet above the ground.
Right. My point is when York gets an application and evaluates make ready, it's taking into consideration any local considerations in the York service territory, correct?
They should, yes.
Okay. And you note that Charter and other communications companies don't provide sag and tension designs by professional engineers or have a professional engineer inspect and certify compliance, right?
Well, charter does in North Carolina because the commission said that they had to, but in most states they don't.
Okay, we'll just focus on South Carolina, and in fact, let's just focus on this proceeding and the issues between York and Charter, okay?
Fine.
Now, in connection with your opinions around SAG and tension designs, you don't provide in your testimony any specific evidence about York or any other South Carolina electric cooperative experiencing any engineering issues with Charter's attachments, right?
Well, I do, because I say charter doesn't provide professional engineering designs. They don't provide professional engineering design to any co-op.
Sir, you understand the difference between evidence and just general comments, right?
How can I provide a professional engineering design when charter doesn't provide that? I know that they don't provide that to York.
Sir, I'm not asking you about professional designs. I'm asking about whether in your testimony, sir, you provide any documentation or evidence around any specific problems with engineering by Charter.
Other than the accident issues, no. York has testified to all those problems.
And the accident issues you're referring to are just the list of cases in your CV, correct?
Correct.
All right. Now, we talked about this earlier, but just to come back to it, you've taken a look at the pole attachment agreement between Charter and York, right?
Yes.
And you'd agree with me that that agreement does not actually require Charter to submit any engineering certification with its pole attachment applications, right?
Not specifically, as I recall the agreement. It says that charter has to meet the laws of South Carolina.
Okay, and it doesn't. And
one
the agreement.
Of the laws of South Carolina. One of the laws of South Carolina.
Okay.
Is
sorry. Go ahead.
Professional engineering design when you're attaching to someone else's property.
Okay. The agreement doesn't require Charter to submit any post-construction inspections either, does it?
Well, it does by virtue that it references the NESC.
Well, that was going to be my next question.
Rule 214A1 says you have to do an inspection of the initial installation.
Well, that was going to be my next question, Mr. Booth. The agreement does require Charter to be responsible to attach at a proper height in accordance with the NESC, correct?
Yes.
Okay. And you'd agree with me?
And to inspect.
The agreement itself does not require to submit a post-construction inspection, does it?
I do not agree with you. The agreement itself requires Charter to comply with the NESC. So it doesn't list every single NESC rule or sub-rule, but the NESC Rule 214A1 requires an initial inspection of construction when completed.
And those inspections can be performed by York under the agreement, right?
They have the right to do an inspection, but that's it's not York's responsibility to do Charter's work. And I don't see how York could do that inspection absent the design standards from Charter.
Well, let's talk about the design standards that are actually called for under the agreement. The agreement actually spells out the information that Charter needs to provide with each permit application, right?
Yes.
Okay. And the permit application template that York uses also requires Charter to provide a list of the poles and their pole number, right?
Correct.
As well as detailed construction plans and location drawings, right?
Correct.
Okay. And are you aware that Charter must also provide York a signed written certification by its director of construction that its attachments are in full compliance with the NESC?
I believe that's correct.
Okay. And are you aware that York also does pre-construction make-ready surveys or write-outs using their own engineers or own engineering contractors?
That's correct.
Okay. And when York's doing the surveys, York can determine all the clearance and strength as specified by the current edition of the NESC and good utility practices, right?
They can, but they have to make some assumptions without having a design from a professional engineer.
Well, but all these things are spelled out in the agreement between Charter and York, right?
I don't see anything that spells out a professional engineering certified design.
Okay.
No.
But again, if the party, if that were necessary, or if York wanted it, the parties could negotiate additional requirements, right?
Yes.
Okay. But these are the requirements that York has actually called for. They're in the agreement, and that agreement has been in place for a very long time, right?
Yeah, and I think that's the reason for the 18 feet and the 84 inches. They're not asking for PE, sealed, signed, sealed designs and post-construction inspections. So they're asking for a little bit more clearance.
And York can do post-construction inspections of charged attachments using York's own engineers under the agreement, right?
That they can, but that's not their responsibility, and they shouldn't have to hire a bunch of employees to do that. That's Charter's non-delegable duty under the NESC.
If and when York performs those kinds of post-construction inspections, that's on Charter's dime, right?
That's, yeah, if Charter pays the bill.
Yeah, and you'd agree with me that in emergency situations, York also has the right to correct clearance problems on its own, and it can bill Charter for the cost of correction.
That's correct, and hopefully one day Charter will pay the bill.
And are you aware that Charter that York can also request Charter to provide additional information about its design specs?
Yes.
Okay. Do you know how often, or if even ever, York has ever asked Charter to provide additional information regarding sag or tension other than what is called for in its permit application template?
I do not know one way or the other.
You don't know if that's ever been done, do you?
Do not.
Okay.
Mr. Warner, we've been going about an hour and a half. I think we could all use a little break.
All right, I'm almost done, but that's fine. I have about 5-10 minutes left.
Let's go ahead and take a quick
Sure.
break.
Okay.
Mr. Booth, we're going to take a quick break. We will be back in 10 minutes at 3:40. Ask you to be on the line, please.
I'll be here.
Thank you, sir. Good afternoon. We are back in the Public Service Commission of South Carolina in the hearing in docket 2022-188-EC. Let's take a roll call of commissioners. Commissioner Irvin, we have virtually. Present in the hearing room, we have Commissioner J. Williams, Vice Chair Powers, Commissioner Thomas, Commissioner C. Williams, Commissioner Caston, and Chair Belser. And we are, do we have Mr. Booth?
Yes.
Thank you. Mr. Booth is still on the stand for continued cross-examination. Mr. Werner?
Thank you, Madam Chair. Mr. Booth, welcome back. Mr. Booth, I was looking at the resume that you supplied in connection with your direct testimony, and if I have this correct, for the legal cases that you worked on, I'm going to put this on the Alma, hopefully you can see this. You actually don't provide any of those cases in your resume in this case, do you?
I do not provide the 1981 through 2022 list of legal cases, no.
Right, what you actually say is that the list will be provided upon request, right?
Yes, it's hundreds of pages.
Okay. We're not requesting it, to be clear. Mr. Booth, I want to talk to you a bit. I'm sorry, I didn't hear you.
Most people don't.
Okay. Well, I'll join the masses and go with the herd on that one. Mr. Booth, I want to talk to you a bit about Comporium. Now, you understand that York has a network agreement with Comporium, correct?
Yes.
Okay. And as part of that agreement, although none of us have actually seen it in this proceeding, York is installing fiber on its network that is going to be used by Comporium, correct?
Yes, they're installing fiber in the electric supply space, and
Okay.
they're going to let Comporium use part of that fiber.
Now, you'd agree with me that that fiber that's going to be used by Comporium is subject to the very same arc flash hazards as Charter's fiber attachments, correct?
No,
And you say no because that fiber, as it's being installed, is being installed by York's electric workers, right?
that's correct.
But
So the equipment. Yeah, that's correct.
right. But the equipment, the fiber itself, has the same arc flash potential as Charter's cable attachments, right?
Yes.
Okay. The only difference is that as of now, when it's being installed by York's electric workers and not communications workers, correct?
That's one difference. The other difference is that the protective equipment is set on non-reclose and the fast curve, which means any arc flash is going to be extinguished in a fraction of a second, which is different than
And again,
the communication workers are exposed to.
and again, your testimony on that point is based on the fact that as of now, York owns that fiber, correct?
Yes, they own and operate it and install it. Correct.
Now, have you reviewed the photographs that were submitted as part of Rich Lupino's testimony?
Yes.
Okay. I want to take a look at some of those with you. And you'd agree with me, just as a general proposition, that York does not permit Charter to attach its facilities in the same pole position that the Comporium fiber is being attached at, right?
I wouldn't. The Charter, the York fiber is being attached in the electric supply space, Charter's cannot be. Comporium has to attach its fiber in the communication space, just like Charter.
Okay, let's take a look at this first photo I'm showing you. Okay, and you've seen this photo before, but if you look there, the separation is 48 inches, correct?
Yes.
And so that is actually outside the electric supply space, right?
Well, I guess not necessarily. The electric supply space is defined as the space on the pole required by the electric utility. So that could be 9 feet, it could be 15 feet. It varies based on all the electric utility facilities.
All right, but you would agree with me that under the NESC, this is an attachment height that, absent York's 84-inch requirement, is a place where Charter could attach because it's even outside the communications worker safety zone, right?
Yes, yes, and if York is going to operate and maintain that facility, and Charter wants to attach at that point, York could move that communication conductor up several feet and make plenty of room for Charter.
It could, because there's plenty of room there between the electric supply line and the communications line, right?
Yeah, so that pole's got a transformer and everything on it. So we've got plenty of room from the neutral to have 84 inches and an attachment for Charter and simply move the York fiber up the pole.
Okay. Let me show you another photo. Let's take a look at the photo on the bottom there. And again, that in this instance, there's a 47-inch separation, and it's the same situation with the prior photo, where that is a place where Charter could attach because it's actually outside or consistent with the communications worker safety zone, right?
Well, that again, the 84 inches could be provided for Charter. And if York continues to own and operate the fiber, they could move that up further up the pole. So that's just a rearrangement that York could do to accommodate Charter.
Well, that assumes, of course, that there's sufficient space on the pole to accommodate an additional attachment from Charter, correct?
If there's enough space on the pole, the 84 inches from the neutral, which is the top of the distribution transformer tank, then yes, and that's frankly consistent with Duke Energy. I mean, their communication conductors are roughly at 80 inches from the top of the Duke Energy distribution transformer tank.
Okay, well, thank you for that, but I really just want to focus you on York and Charter. We can put Duke Energy to the side. I really just have a few more questions, and I would love it if you just focus on those. My question with respect to this one is that the Comporium attachment is at a separation of 47 inches, which is actually a location where Charter could attach, but for the requirement that Charter actually needs to have 84 inches of separation, right?
Now, I guess to make it clear, is this York's fiber line or Comporium's fiber line?
This is, well, we're not entirely clear, but I believe this is a fiber line that is installed by York for Comporium.
Yes, and well, yeah, so York's fiber lines could be as high up at the neutral position. In other words, they don't need, because they use electric utility workers, they don't need any communication worker safety zone clearance. So if we've got 84 inches from the neutral or the top of the distribution transformer tank down to allow an attachment, then York can simply move their line to make that space for charter. That would be no make-ready work to speak of.
Okay, and sir,
This is a simple move.
I really just want you to answer the question that I'm asking you, and I'll try it again, and maybe I'm not being clear, but looking at this attachment itself, this place on the pole at 47 inches of separation from York's neutral is a place where charter itself could make an attachment if that attachment were not there, right?
Not if we met the 84 inches from the neutral.
Precisely, but it is a place where charter could attach if it simply complied with the communications worker safety zone, right?
If we cherry pick the 40 inches from table 235-5 without considering the rest of the code, yes.
Okay, and I just want to focus you on the communications worker safety zone. That's not in the code. I'm not asking you about the Greg Booth arc flash zone. I just want to focus on the 40-inch zone that's in the code. If you did not have the 84-inch requirement that applied to charter, but not Comporium, this is actually an attachment that charter could make, right?
At what point? I mean, if we consider this fiber communications, then there has to be 12 inches. So again, no. But if we consider it electric utility, then yes, it can be moved up the pole. And if the requirement is only 40 inches or 43 inches, charter could attach there.
Right, exactly. Thank you very much. So you're aware, of course, that York, under its agreement with Comporium, is ultimately going to transfer title to the fiber to Comporium, right?
Mr. Bash's testimony will speak for itself, but my understanding is that decision has not been made yet.
Okay, well, let's just hypothetically say that there does come a time when Comporium owns that fiber and is accessing it with its own communications workers at that point. If that's the case, then they will have fiber that's in a place that does not comply with your arc flash hazard zone, correct?
No, I wouldn't agree with that, because if Comporium acquires that fiber in the electric supply space, then that agreement would mandate that all workers that work on those facilities be qualified electric utility workers. Otherwise, you have to move the fiber.
Otherwise, they'd have to move. But you're saying that there may be some other future hypothetical agreement that will allow that fiber to stay there. Is that right?
I mean, there's no question, if there's a hypothetical sale of the fiber to a communication company, that agreement for that fiber to stay in that place must include provisions for only electric utility workers to be allowed to work on that fiber in that space.
So let's go with that hypothesis. So if it comes a time when Comporium takes over the fiber, has its own communications workers, and does not have the ability to have electric workers, your testimony is that they'd have to move down, right?
That they'd have to move down or use qualified electric utility contractors.
And if they had to move down, all the other communications attachers are on the pole would have to move down too, right?
We don't know the answer to that without looking at the design of every pole. We don't know the space.
Right, but you can assume if Comporium has to move down and there's a charter attachment below it, then charter is going to have to move down, with the end result being that the pole is going to have to be changed out, right?
But again, that's a pole by pole design. So if you've got adequate space for Comporium to move their fiber down to 84 inches from the neutral, and charter can be 12 inches below that, and you have a tall enough pole, you may not have to change it.
Well,
I mean,
that's
that's a pole by pole design. I
That-
can't answer that.
Let's talk about this pole that we're looking at here. If Comporium had to move instead from 47 to 84, wherever charter attached, it would have to move down. And you would agree with me, at that point, you could not meet the midspan 18 feet requirement and the pole would have to be changed, right?
I don't know the height of the pole. I don't know what the midspan clearance is. I don't know the span length. There's so many things you have to know to answer that question, and they're not here on this diagram.
Right, okay. No further questions. Thank you, Mr. Booth.
Thank you.
Thank you, Mr. Warner. South Carolina Telephone Coalition,
No questions, Madam Chair.
AT&T,
Thank you for the opportunity. No questions.
Office of Regulatory Staff,
No questions for us. Thank you.
Commissioners,
Madam Chair,
Commissioner Thomas,
thank you. So, Mr. Booth, I have a couple of just basic questions for you that I hope will help me to just get some little bit of clarity and basic understanding. So, I've heard some talk about the closer, recloser, non-recloser, and electrical workers and communication workers, and that those things help the electrical workers, but not the communication workers. Can you just tell me just a little bit about what is a closer, recloser, non-recloser, and how they work and why it applies to one but not the other, please?
Yes. So a circuit recloser is a device that detects fault currents. So that would be two conductors getting together or tree hitting a conductor, the things that cause your lights to blink or go out altogether. They operate 4 times typically to lockout. So the blinks you see are the recloser opening and closing for a tree limb or a squirrel or any number of items. When your lights go out, it's going all the way through all of its operations and done what's called a lockout. All those reclosers have a device on them. Some are just a yellow handle. You pull it down, and if there's a fault, the recloser trips and locks out on that one operation. So under the work rules for electric utility employees to work on or near energized conductors, that those automatic circuit reclosing devices have to be set so they will not reclose back on the fault or on the worker. So that means that if, let's just say a worker makes a mistake and connects a stinger, the line that goes to the primary, from the primary and connects it to a neutral or something grounded, or bump something grounded, instead of hooking it to the bushing, which isn't grounded, then that's going to cause a fault. It's going to cause an arc flash event, but that event's going to be interrupted in plus or minus a 1/10 of a second, so very rapidly, and it won't close back. So that not only protects the worker, but it also means the arc flash doesn't last nearly as long. And so the heat, which can be 5 to 15,000 degrees Fahrenheit, that comes out of the arc flash doesn't travel out very far because it's extinguished very quickly. A communication worker, you don't know they're out on lines. There's no requirement for the non-reclose feature, and it's not used for communication workers. So if something happens there with an arc flash, you've got this slow curve of the recloser that could take a second or two, which in the electric utility industry is an eternity for a fault, to operate. So this arc flash allows the heat, rather than traveling maybe 10 inches or 12 inches or 18 inches, to travel much, much greater distances. And that calculation has to be done for every system and every voltage. Different systems, it wouldn't be a problem. York system, we identified that it's a safety problem for a communication worker.
Okay. So let me move on to my second question, and this relates to the NESC rules. And at a high level, my understanding is that there are different rules, or there's flexibility depending on where something is and what's going on. Anything from clearances when you're going over a waterway, to flexibility if you're out in the country where there may be big tractors. And then there are a little bit more detailed and specific rules. And I'm trying to make sure I understand that a little bit, that Rule 235 and Table 235-5. So this is my understanding, and would like for you to correct me if I'm wrong. So the rule is based on 8.7 kilovolts going through the system. And then that's where that 40-inch standard applies if it's 8.7 kilovolts. And then York operates at 14.4 kilovolts is my understanding. So they're at 5.7 kilovolts higher than the standard rule. And once you do that, then you need an extra 4 inches for each kilovolt. So if you do the math, 5.7 times 4 inches, that means you need an extra 22.8 inches. You add that 22.8 inches to the 40 inches and you come up to 62.8 inches. So basically, if I'm reading and understanding correctly, that's kind of would be the general rule that would apply to York under that table. But they're kind of going with an 84-inch rule. Does any of that make any sense?
Well, it's 4/10 of an inch rather than 4 inches.
Okay.
So at 14.4 kV, that's just an additional 3 inches. So the 40 inches for a phase to ground voltage of 14.4 becomes 43 inches.
Okay. Thank you. That's what I wanted to know. That's all I have.
Thank you, Commissioner Thomas. Commissioner Caston.
Mr. Booth, good afternoon.
Good afternoon.
Just very few questions. Have you performed any professional engineering work for York Electric relative to their distribution system?
No, sir.
Are you familiar with it?
Yes.
Were you familiar with York's pole standards since 2004?
Yes, I've been working in South Carolina since the 80s and doing work for co-ops in South Carolina and doing courses in South Carolina. So I'm familiar with pretty much all the co-op systems there.
So you're saying you're fairly familiar with all of the co-ops pole standards?
Yes, so rural utilities service has thousands of standards. That's basically the federal government developed all these standards and they've been updated. And the roughly 900 electric co-ops, including those in South Carolina, follow those design standards and bulletins for the construction of their system. So whether you go to Jones Onslow EMC in North Carolina, or York in South Carolina, or Florida Keys Electric Co-op in Florida, they're all applying those RUS standards. And they're
thank you.
applying the NESC and the strength rules in the same fashion.
Are you familiar with the BAA?
Yes,
Are you aware of any aspect of the BAA that York is not complying with?
I'm not aware of any portion they're not complying with.
In your opinion, why is this an issue now?
Well, this is, I guess this is me speculating, because I'm quite surprised that everybody was happy for 20 years, and now all of a sudden it's a problem with York, and yet Charters doesn't have any problem being 80 plus inches from a Duke neutral, or from a Duke, top of a Duke transformer tank, for instance, but they have a problem of being 84 inches from the top of the tank, which happens to be the neutral position. In York, all of a sudden, I'm guessing it simply goes to trying to find a way to reduce the cost of attaching to York poles in areas that are already serving and planning to serve. You know, that's what I've seen in other states. The Charter and the communication companies are hoping to get regulatory commissions to, you know, make things cheaper for them to operate, transferring cost over to the electric co-op.
All righty, thank you. I have no more questions.
Commissioner, Vice Chair Powers?
Thank you. Mr. Booth, just a couple of questions. I built a couple of houses and refurbished some old houses myself, and both with the co-op and I think it's Dominion. Anytime you talked in your testimony that if there's any construction, then you have to put a transformer up. The construction I did, they always just put up a temporary pole to do that, which is more common. Is it going to be necessary with construction in a rural area to put up a transformer, or would it not be done with a temporary pole set up?
You have to have both. So there has to be a distribution transformer to transform 14,400 volts down to the 12240 volts you have to use. And what happens is they extend from that transformer, either whether it exists or they have to add one, they extend a secondary service drop to a lift pole, which is a temporary lift pole, and a temporary meter is put on that pole that you're familiar with, and they bill you for your electric usage at that temporary pole. But the actual power that comes with that temporary meter is coming from a distribution transformer and a 12240 secondary service conductor. So you have to have the transformer.
Okay, thank you.
Thank you, Vice Chair Powers. Commissioner Jay Williams?
Thank you, Madam Chair. Good afternoon, Mr. Booth. How are you today?
I'm doing well. I hope you are.
Thank you for serving as a great example of husbands everywhere by going home to take care of your wife. I appreciate that.
I really appreciate the commission allowing me to do that.
Well, that's a good thing. So you said something that caught my attention. I'm just trying to better understand the clearance requirements. I understand that York's clearance requirement for communication lines is 84 inches, and I believe counsel for Charter asked you about 100 inches. Do you remember that?
Yes.
And I think I remember you saying that you wouldn't recommend that clearance, but I didn't really understand why. You wouldn't recommend that?
It would be completely unnecessary. So the 84 inches is all that's needed in order for York to be able to have space to put its transformer up, which it had already built its system to plan for, and its services to its members. And 84 inches is adequate to make sure that communication workers are outside of the arc flash hazard incident energy heat area, the heat that could potentially catch their non-flame retardant clothing on fire. Anything greater than 84 inches would be completely unnecessary, and I wouldn't recommend it.
Okay, I understand that, and thank you for sharing that with me. And from my understanding of this case, the only reason we're really going through this exercise is because of the Broadband Accessibility Act. Is that fair to say?
That's what it appears to be to me, yes.
Okay. And so there are, different interpretations as to what that act really means. That's also fair to say, right?
Yes, and I think that's why it's here for the commission to make that decision.
Right. I agree with you, sir. So you established that you were not a party to the decision for the 84-inch clearance requirement, made back in, I believe, 2002.
That's correct.
Okay. But based on your analysis of this case and the facts that exist therein, you find 84 inches appropriate.
I do, and it's in part because I've worked with hundreds of co-ops on attachment agreements and establishing between 72 and 84 inches, including back in the early 2000 timeframe. So it's consistent with what I see across many co-ops throughout the country.
Understood. So let's go through a hypothetical and see if this makes sense. Let's just say XYZ co-op somewhere in America made the decision for a 100-inch clearance requirement, and they said that it's based on safety in their particular area because of equipment that has snag lines for access for their workers and for growth that they expect in their service territory, essentially identical to what York has said. And they said that 100 inches is appropriate. Would that be enough to justify 100 inches, even though you don't right now, based on what you know? Obviously, this is a hypothetical, but would that be enough to justify 100 inches?
That there would have to be something else in their requirements that justified the 100 inches. But if everything was the same as York's system, then no. Or if everything is the same as a typical co-op, then the answer is no.
Okay, so it sounds like what I'm hearing you say is that if there was not some justification for deviating the NESC standards, that deviation would not be appropriate.
That's correct. You would need to have a series of reasons to deviate from the all the NESC standards, taking everything into consideration.
Well, what if I just wanted to because I'm the pole owner and it just fit my business model? My prerogative.
Well, if it just fits your business model, I wouldn't see that as an appropriate reason to make the change. The change would have to be for efficiencies, reliability, safety. I mean, you can't just because you want to transfer a cost to somebody else wouldn't be appropriate, in my opinion.
Well, I could have missed something in this case, but is there any document, report, benefit cost analysis, something from 2002 when this decision was made to support the reason for making that decision at the time that you know of or that you've reviewed in this case?
I've not reviewed anything. I'm unaware of a cost benefit analysis or any documentation other than the general reasons laid out by York.
All right. Thank you, sir, for your testimony. Hope your wife feels better.
Thank you very much.
Thank you, Commissioner Williams. Commissioners, any further questions of this witness?
Madam Chair,
Commissioner Urban?
thank you. Mr. Booth, good afternoon, sir.
Good afternoon.
You mentioned that this kind of litigation may have come up in other jurisdictions. Are you aware of other states that have recently passed broadband expansion legislation that have gone through similar litigation?
North Carolina and Georgia. The latest one that I testified in was Georgia, that has similar broadband legislation. And the fight in Georgia was much more expansive than this one. So it went to every single issue, including how the agreement should be written. They sided on virtually every issue with the Georgia co-ops, the commission did. But it was a similar but much more expansive debate.
Was the Georgia statute for broadband expansion similar to the South Carolina legislation that was passed and signed into law?
I'm going to say yes, but I haven't done a line-by-line comparison. But yeah, the co-ops in Georgia can extend fiber optic cables for broadband purposes. They can get into that business now, the electric co-ops.
And you testified for the co-ops in Georgia?
I did.
And also in North Carolina?
I did.
What happened in North Carolina?
North Carolina required that the communication companies have a licensed professional engineer design the communication facilities, and that design has to be provided to the electric cooperatives. The fight there was also over pole attachment rates and some other issues. I would say that the communication companies won on the pole attachment rate issue. They got a much lower rate than had been charged in the past, but they lost on many of the other issues, and most specifically, the application of NESC and professional engineering design. They have to provide a professional engineering design and a final installation certification.
When you say they, you're referring to whom?
Charter and other communication companies operating in the state.
And has that litigation in North Carolina run the appellate court? In other words, have all appeals been exhausted, do you know?
I do not know. My recollection is it wasn't appealed by anybody. But I don't know for sure.
I understand. But there's a North Carolina public utilities order that was entered that resolved the case to the best of your understanding?
Yes, sir. I've seen that order and have a copy.
And did the similar outcome in Georgia? Did the Georgia Commission enter an order resolving the matter?
Yes.
And was it appealed, if you know?
I do not know.
Okay. Well, the interesting issue in this case, it seems to me, it probably unlike Georgia and North Carolina, is that what we have here is, a pre-existing.
Commissioner Urban, we've lost your sound.
Okay, can you hear me now?
Yes, sir.
Okay, thank you.
We didn't catch what you were saying.
I'll repeat the question. And if you can't hear me, Mr. Booth, let me know, okay?
Yeah, I've heard you fine.
Thank you. My question is, here we're dealing with a slightly different factual scenario where the co-op entered into an agreement with Comporium and allowed them to essentially, I guess, finance the deal over a period of years with the understanding, pay carrying costs, that ultimately they would have the option of owning the line. Is that your understanding?
That's kind of a thumbnail sketch, but I think the co-op used their funds to finance it, and then they're gonna get payments back.
They'll get paid back with interest.
They'll get paid back over time, and that's assuming Emporium even stays in business, 20 or 30 years.
So I guess if one were looking at this unique set of facts, does that not give Comporium an unfair advantage when considering all other comers, whether it be Charter, Spectrum, or AT&T, or any other person that wants to provide broadband services to an unserved or underserved area as defined by our South Carolina law? Aren't they at a competitive disadvantage now?
I don't think so. First, North Carolina and Georgia have similar types of arrangements between co-ops and fiber broadband providers. And because this belongs to York and is in the electric supply space at a cost, a significant cost to York, and what will be a significant payments made by Comporium, any other broadband company, Charter or anybody, can attach to the poles with their own facilities to provide competitive services on the same pole, just not in the electric supply space. So I don't think there's any real competitive advantage. I guess what one would have to do is really sit down with all the numbers and run through the numbers and see if there's some type of competitive advantage that was created. But just on the surface, I don't see one.
But you weren't asked to run the numbers, I don't suppose.
I wasn't. I was not asked to look at the Comporium economics versus the economics for Charter, AT&T, or anyone else.
Do you feel like you'd be qualified to do so if you had the underlying facts?
I do. I've done cost of service studies, rate studies, this type of work, and testified on them at commissions for years. So this is the type of thing. I've actually done the cost benefit analysis for my own clients to get into the fiber business themselves, broadband business themselves, and in fact did the engineering and construction work for those clients. So I'm quite qualified to do that.
Okay. Well, what additional facts would you need in order to do such an analysis?
We need all of the cost and operating economics associated with the fiber lines from both Comporium and from York. So we'd have to have all those numbers. We'd have to take the...
For what period, sir?
Well, what we would do is we take today's actual cost, and then we'd have to escalate that over time. You typically escalate that over the 20-year life of the contract. You'd present worth that back, and you'd come up with a 2022 or 2023 present worth value through a cost benefit analysis. And then you would have to get a comparable set of numbers from a Charter or an AT&T or someone to attach their facilities and their full operations to provide the same service in the same area to see if there's any substantial difference. I mean, it's not only quite an undertaking, but I've not seen companies like Charter, AT&T willing to let you have those kind of numbers so you can see what their profits are. So that might be a challenge to get the other party's numbers. Getting a nonprofit's numbers might not be too tough.
Well, you've represented some private carriers in the past, haven't you? So you're familiar with their business model.
I am.
So is that, if they wouldn't provide it, isn't there readily available data that you could apply to a model?
That you could certainly insert a series of assumptions. I think that the profit assumption, I guess you would, the way I would go about it is I would establish what their profits are off of their filings with the SEC and their stock filings, since they're stock traded companies, and I'd try to use that as the best available data.
So if the commission asks you to do this analysis, how long do you think it would take you to pull those numbers together and perform that analysis?
Well, I guess since I'm at the mercy of other people and having done this stuff before, it could take 6 months.
Well, we normally don't leave the record open that long. We have deadlines that we have to meet that would preclude, waiting 6 months. Is it not possible to do it in 30 days or so?
It wouldn't be for me and my staff, given the workload we have with other regulatory matters and electric utility client matters, and cost of service studies. But you might find somebody that that could do that.
Have you ever done a study like that for a client or in the past?
Yeah, I've done those types of studies. Most of them have been in Virginia, where electric co-ops have either gotten into the business or not. One of the studies was between Shentel, and an electric co-op. We had a study with an electric co-op and a private broadband company that wanted to sell out to the co-op on Eastern Shore of Virginia. But those studies got to a point and everybody stopped proceeding with the process. I've had a couple of co-ops that the studies showed the economics were close to break even, and their members wanted it so bad, the members were willing to take that risk. And so the co-op, both in Bath County and Prince George County and other places, installed broadband to meet their members' desires.
Did you say you had a copy of the Georgia Commission order and the litigation you were involved in there?
I have the North Carolina order. I'll have to double check whether I have the Georgia order or not, but I can certainly download it from the website easy enough, but I think I have it.
Would you be willing to submit that as a late file exhibit to the commission?
Yes.
In 7 days.
Madam Chair,
Yes.
I think that probably ought to be the party doing that, and we will we will submit those.
We could take
orders.
judicial notice of them, but I
That-
still think we need a copy of the final order.
It doesn't need to come through the witness. And,
Right.
And
Okay. Maybe you could just provide us with the order number, the date of the decision.
I
the
think
order
that's
number.
something that the attorneys can work out.
All right. Thank you. Those are all the
Potentially.
questions I have, sir. Thank you so much.
Thank you.
Commissioners, further questions? Redirect?
Mr. Booth, you there? There.
Yes.
I'm going to follow up very briefly on the questions that Commissioner Irvin asked you about the study. Did you review the petition that Charter filed that initiated this proceeding?
Yes.
Did you see any allegation, any claim related to the agreement between York Electric Cooperative and Comporium Communications by which Comporium or York is allowing Comporium to use capacity on fiber network that York is constructing?
No.
Have you seen the exhibits that were attached to Mr. Bash's testimony that was correspondence between the lawyers, letters and emails about that agreement where the York lawyer, Mr. McDonald, provided Mr. Werner and his colleagues information about that agreement?
Yes.
So would it be fair to say that at the time this petition was filed, the Charter and its lawyers knew about the agreement between York and Comporium that Commissioner Irvin was asking you about?
Absolutely.
Thank you. No further questions.
Anything further, this witness? Very limited. Well, and very limited.
Very. I promise. Mr. Booth, good to see you again. I just want to
Yes.
follow up on Commissioner Irvin's questions, and in response to some of them, you discussed the North Carolina proceeding. Do you recall that testimony?
Yes.
Okay. Now, you'd agree with me that the North Carolina Commission actually agreed with Charter that the utilities could not reserve space like York is trying to do here, right?
That's correct.
Okay. And the North Carolina Commission actually found that the utilities position would be inconsistent with the North Carolina statute's access rights afforded to Charter, right?
That's correct.
Okay. And you'll recall, of course, that the commission also concluded that the utility there could not reclaim space for it to be used by an affiliate to provide communication services in competition with Charter, right?
That's correct. Not for an affiliate, but for their own use, they can.
No further questions.
Thank you, Mr. Warner. Mr. Booth, thank you for your testimony today. You may stand down, and good luck. Wishing your wife a speedy recovery.
Thank you, and I greatly appreciate you accommodating me on this virtual testimony.
You're welcome. Mr. Ellaby?
Would ask that Mr. Booth be excused, and I understand that's at my risk.
Yes, sir. With that admonition, you may excuse your witness, but thank you. Okay. Mr. Willoughby or Mr. Werner? We've got Mr. Lupino.
Madam Chair, given the hour, would it be appropriate to
We're ready to move forward.
adjourn? Well, could we have, it looks like we can certainly get in his summary, but we would like to have.
Well, we can go till about 6 or so. We're ready to go.
Okay. We would call to the stand Mr. Rich Lupino.
Thank you, sir.
Madam Chair, I need to check with the IT department about, we were going to show in his summary a couple of his exhibits. I need to make sure they're set up.
Do you solemnly swear that the testimony you'll give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon.
Please state your full name for the record.
Richard Lupino.
And by whom are you employed and in what capacity?
Charter Communications. I am the Senior Director of Construction in South Carolina.
In connection with this proceeding, Mr. Lupino, did you prepare and cause to be pre-filed rebuttal testimony consisting of 26 pages?
Yes.
And did you also have attached to that testimony, I believe, 2 exhibits? Is that right?
Yes, sir, I did.
Do you have any corrections or changes to be made to the pre-filed rebuttal testimony?
No, sir.
If I asked you the questions today from the stand that appear in that pre-filed rebuttal testimony, would your answers be the same?
Yes.
Madam Chair, we would move the introduction into the record as if given orally from the stand, the pre-filed rebuttal testimony of Mr. Lupino.
Mr. Lupino's pre-filed rebuttal testimony will be entered into the record as if testified to from the stand.
Thank you very much. Mr. Lupino, in regard to your 2 exhibits, are there any corrections or changes to be made to them?
No, there's not.
Madam Chair, we would move the introduction of Mr. Lupino's exhibits, 2 pre-filed exhibits, into the record as, I guess, the next composite exhibit.
Mr. Lupino's pre-filed exhibits attached as direct testimony, I think they're RL-1 and RL-2, will be marked for identification as hearing exhibit 9 and received into the evidence of this case.
And that is to his rebuttal testimony.
Thank you. His rebuttal exhibits RL-1 and RL-2 as a composite exhibit.
Thank you very much, Madam Chair. Mr. Lupino, have you prepared a summary of your rebuttal testimony?
Yes, sir.
Please deliver that at this time. And just give me a thumbs up when you're ready for me to display the exhibits.
Yes, sir. Chairman Belzer, members of the commission, thank you for allowing me to testify today. My name is Richard Lupino. I am the Senior Director of Construction at Charter Communications. I have over 30 years of experience in the communications industry and particularly outside plant practices. I've spent my career working in fiber optic and copper cable, outside plant engineering and construction, including working as a lineman for several years. I've also worked for companies in South Carolina that owned utility poles, such as York itself, or like York itself. I live and work in South Carolina. I've spent many hours driving through York's territory and serving territory, analyzing its poles and looking at its plant and the attachment to these poles. I care deeply about the community. I am and always have been committed to keeping my workers safe along with the public while working to provide broadband in South Carolina. In my rebuttal testimony, I do discuss York's stated justifications for its 84-inch vertical and 18-foot mid-span clearance separation. I also discuss York's more favorable treatment of its broadband partner, Comporium, as compared to Charter, and the impact that difference in treatment has on Charter and its ability to timely and cost-effectively deploy broadband in South Carolina. I will address each issue in turn, and I will start by summarizing my testimony on York's stated justifications for the clearance requirements it seeks to impose on Charter. I respectfully disagree with York's witnesses that York's clearance requirements are justified by safety or other concerns. Charter and York agreed in their pole attachment agreement to procedures to promptly address any pole compliance issues. For example, York performs make-ready surveys that includes an engineering analysis to determine if the pole is able to receive the additional attachments that Charter pays for that survey every single time. York may also conduct inspections of Charter's pre- and post-construction work, also at Charter's expense. In his testimony, Mr. Basha explains the real reason for York's standards. He says that York imposes an 84-inch clearance requirement to, in his words, manage York's membership growth and minimize its own upgrade and make-ready work. That all may be true, but it is not fair or reasonable for York to shift those costs of managing their growth to Charter. However, that is effectively what York is doing by requiring Charter to pay York to install taller poles to accommodate those Charter attachments. This means the Charter would end up subsidizing York's costs to serve these new customers. In my testimony, I also address York's discrimination against Charter and the impact that has on Charter's ability to deploy broadband in South Carolina. York does not require its broadband partner to comply with the same 84-inch vertical clearance and 18-foot midspan requirements that it is trying to impose on Charter. Last month, at my direction, my team went out and took several pictures of Comporium attachments to York poles, and we found that Comporium is not being required to comply with the same vertical clearance requirements that York wants to impose on Charter. I would like to briefly summarize what a few of those photos show. This is Exhibit 1, Mitchell. On page 4 of Exhibit 1 to my testimony, I include two examples of Comporium attachments. The top row of pictures show a Comporium attachment at 38 inches below the neutral, which is in violation of the NESC standard and of York's 84-inch clearance requirement that it's trying to impose on Charter. The second row of pictures shows a Comporium attachment at 47 inches below the neutral, which is less than the 84-inch rule that York is requiring Charter to attach in. Additionally, on page 3 of Exhibit 1 to my testimony, I include one example of a Comporium attachment with a midspan clearance of 15 feet, which is less than the 15.5-foot clearance requirement in the NESC and the 18-foot attachment or midspan clearance that York is requiring of Charter. These pictures prove a basic point, and that is that York is not requiring Comporium to maintain the same clearances as Charter. That difference in treatment is a large problem for Charter, and it means that York's clearance requirements will require Charter to replace many of York's poles with taller poles in order to attach. For example, Charter would have to replace the majority of York's 35-foot poles in their territory that Charter plans to attach to. That's about half of what Charter planned on attaching to for its RDOF build and submit applications for. At York's cost of $6,000 to replace a three-phase pole or $4,000 for a single-phase pole, that cost is very significant and an unnecessary cost. To be clear, if York wants to require pole attachers to attain in excess of the NESC requirements, York should not be allowed to require Charter to pay those additional costs to achieve those clearances beyond what Charter would normally pay if we attached at the NESC 40 inches and had the 15.5-foot midspan requirement. To require Charter to pay those additional costs is unfair, unreasonable, anti-competitive, and discriminatory. This concludes my rebuttal testimony. Thank you for the attention to this matter and consideration of Charter's petition.
Madam Chair, the testimony is in the record and the witness is prepared to address questions from the parties and the commission.
Thank you, Mr. Willoughby. York Electric.
Mr. Lupino, good afternoon. My name is Frank Ellerby. I think you've been here the last couple of days, so you know who I am.
I have,
right?
sir. Yes. Good to meet you.
And you have heard the testimony that the lines that you identified in your rebuttal testimony and in the summary you just gave, that are shown on those pictures, are not Comporium lines. Haven't you heard that testimony?
I have heard that.
And yet, you went ahead and took the oath and didn't change your testimony, and you're still calling those lines Comporium lines.
When I did address those and have the pictures taken, it was our impression that they were Comporium. And they do have Comporium labels all over them.
Well, but that's the pedestal, right?
I've also seen fiber tags with Comporium on them.
Do you know that those lines, contrary to what Mr. Bash has said, are actually owned by Comporium?
I don't know that for a fact.
Do you think your testimony should be changed to reflect that they are lines that York is providing to Comporium under the agreement that we've talked about?
If those exact poles that I sent pictures in are truly York, then perhaps it should be changed. But if that's those are not York's, I don't know that for sure.
Well, how did it come to your attention? How was it suggested to you that you send somebody out to take those pictures, Mr. Lupino?
When we were told that we had to address the commission here, we wanted to see if there was any issues with Comporium being at different attachment heights than we were being required to.
Because you have seen the agreements from back in 2002 and 2004, pole attachment agreements that York has with Comporium and with Charter. You've seen those agreements.
Yes, I have.
And they have the same requirements in those agreements, right?
Very similar, yes.
Okay. And with respect to the other areas of York's service territory, not this rural area where these photographs were taken, you're familiar with the Comporium practices under their agreement in terms of where they attach, right?
I believe so.
Okay, because your Charter's got facilities in those areas, and Comporium has facilities in those areas, and y'all are competing for broadband customers in those areas. Is that right, sir?
In some areas, but most areas we don't overlap each other.
But you're trying to get into new developments, for example. A new development comes in, you might bid to go serve there, and you want to be the first one in there?
Not usually if it's outside of our footprint, no.
Okay, but you expand your footprint over time, don't you?
In some cases, we do.
And attach to new poles or go underground in new areas, right?
In some cases, yes.
So you're familiar with what Comporium's attachment practices with respect to York poles in the areas where we're talking about, where y'all have been providing broadband, perhaps near each other, but maybe not on the same street?
Yes, sir.
Okay. And you haven't noticed discriminatory treatment for Comporium in those areas, have you, Mr. Lapina?
I had never built fiber with Charter in the BAU world. I was brought on board in Charter in April of 2021 to particularly work on the RDOF build. So I'm not familiar with any practices before April 2021.
But the people that were sent to take the photographs didn't go into that area I was just asking you about. They went into the rural area where Mr. Bash has explained York is extending fiber to its members who haven't ever had broadband offered to them.
They weren't given specific instructions where to go. They were just asked to put some pictures together of some Comporium plan.
Okay. What role did the Charter lawyers play in this effort to direct where the photographs were taken?
Madam Chair, that invades attorney-client protected privilege. It invades the questions of attorney work product. The pictures speak for themselves, and the fact that Mr. Ellerby doesn't like the pictures, doesn't like the fact that they demonstrate what they show what they show. And the picture's in evidence, and I don't think he can invade what directions this gentleman may have received from any counsel from any counsel.
Mr. Ellerby, that does seem to get into some.
As long as, well, that's fine. I take it then that the lawyers were involved, and I don't want to know about anything the lawyers had to say.
I don't think you can take anything, Mr. Ellerby.
Well, I think that would be the basis for your objection, Mr. Willoughby, but I shouldn't be talking to you. I should direct my comments to the chair. Why don't I move on?
Excuse me.
Did anyone tell you?
Madam Chair.
Vice Chair?
Could the witness pull the microphone closer? I was
I'm
having
sorry.
a hard time hearing you. Thank you.
Better?
Much better, thank you.
You mentioned you just came to the York service territory in 2021. Your first involvement in the York service territory was in 2021. Is that right, Mr.
Yes, sir.
Lapina? So you didn't have any involvement back in the early 2000s when Mr. Basha made the changes to the agreements, the clearance changes, right?
No, I did not.
So you can't tell this commission anything about the responsiveness of communication service providers to requests to move facilities or paying bills back in the early 2000s, can you, Mr. Lapina?
I don't have an intimate knowledge of that, no.
Where were you where were you working in the early 2000s?
In the early 2000s, Verizon.
Okay, and then you worked for Frontier for a period of time?
Yes, sir.
When did you actually start working for Charter?
The end of 2017.
Okay. Did you have any knowledge that there was an agreement between York and Comporium regarding fiber being extended into rural areas of York service territory?
Could you repeat that, please?
Yeah. When did you first become aware that there was an agreement in place between York Electric Cooperative and Comporium by which York extended fiber into rural parts of its service territory, and Comporium then could use that fiber to offer broadband to those folks?
I believe it was sometime in either June or July of 21. I had some conversations with Craig Spencer, who is the Vice President of Engineering with York Electric, and we were trying to arrange a meeting, and during one of our phone calls, Craig Spencer said, just to be forthright with information, York is placing fiber on our poles and getting into broadband.
And that was York putting fiber on its poles?
Yes.
Okay. And you heard Mr. Bash's testimony that fiber is going into areas that are unserved. Did you hear that, sir?
I did hear him say that, yes.
And so that's an area that Charter, as of now, has chosen not to serve.
I don't know that. From what I've seen, the areas, if you look at York's own website and look at the map of where they're building, it overlaps about 80% of where we were awarded RDOF dollars. So there's a huge overlap in the areas that both companies are building. And so we're both building in some of the same areas.
But they're unserved areas, right?
Yes, the RDOF award right now is for totally unserved areas.
Right. So Charter has, as of today, made the choice, or excuse me, in the past, before the application for RDOF, Charter had decided it would not serve those areas.
That is correct, because at that time, there was no funding available to help assist with the build, which was exorbitant to build some of these rural areas.
Right. And those are the areas Mr. Basher described that York Electric Cooperative decided it would try to build, right?
Yes.
Are there any Charter facilities attached to the poles shown on your pictures?
Oh, not that I know of, no.
And you looked at I assume you looked at the pictures to see whether there were any Charter facilities on those poles.
I did look at the pictures, yes.
Okay. And you didn't find any?
We may be buried in that area, but
In a rural area that couldn't support service?
we're burying a lot of our cable because we could not come to an agreement with York.
Do you know, Mr. Lupino, whether there's a statutory process by which Charter could make arrangements to obtain under a non-disclosure agreement the contract between York and Comporium?
I don't know anything about that now.
You're the only representative of Charter that we've had a chance to talk to, so I thought I would try you with that question.
That has nothing to do with me. I'm overseeing the construction. I'm not overseeing the legal aspect of it.
But you were the person that was given the task or the job of coming in here and describing Comporium attachments when it turned out they were really York electric facilities installed on York's poles by York, right?
I didn't know that that was the position that York had, that they own that fiber.
Although Mr. Spencer told you that York was installing fiber on its poles, right?
I don't know if he said it was York or if he had contractors. I do know that at our first meeting that we had, we saw fiber contractors at their building. So I didn't know whose they were.
I thought you told me that Mr. Spencer told you that York was putting fiber in place on its poles.
He did say that York was getting into broadband, yes, and placing fiber. Okay. Whether that was York itself, I didn't know that.
Okay. Thank you, sir. No further questions.
South Carolina Telephone Coalition.
Thank you, Madam Chair. Mr. Lupino, I'm Brad Wright with the South Carolina Telephone
Good to
Coalition.
meet
How
you,
are
sir.
you today? Got just a few questions.
Mr. Wright, I am going to ask you to try to get as close or stand in front of that
Sorry.
microphone as you can.
Is that a little better?
Yes, sir.
So I know some of this ground was just covered with respect to the pictures that you took and that were attached to as exhibits to your testimony. You can't definitively say that any of those are Comporium attachments. Is that correct?
Well, when we saw the Comporium name, we assumed They were
Where did you
Comporium.
see the Comporium name?
They do have fiber tags in some of their poles, the orange tags up at the attachment. And
But you didn't provide any of that in your testimony. It's not provided as an exhibit.
no, I didn't have my my field team go up in a bucket to get pictures of.
But you did
close
provide
up.
stuff for the handhold that had
Yes,
Comporium
sir.
on it, which
Yes, sir.
would be part of the service. But you don't have anything in your exhibits that shows that the fiber is Comporium's, do you?
No,
Do you have any reason to believe that Comporium actually installed this fiber on the poles?
I don't know that. No,
I mean, your testimony in a couple places suggested that Comporium was violating
it did.
the CWSZ, but you don't have any actual. You didn't.
I get that from my team that's in the field every day, and they thought it was Comporium installing that fiber.
We've talked a little bit about RDOF. RDOF is federal funding that's intended to help providers get out to unserved areas. Is that correct? The areas we're talking about here that have fiber on poles is already served. Is that correct?
Some of those, yes.
Bear with me 1 second. Can you tell me when you took the pictures that are attached to exhibits?
I believe it was
As
August 2nd.
August
I think
2nd.
It's in the.
I have page 7 says August 2nd. Is that right?
It's not on my page 7. Yes, August 2nd, 2022.
And those pictures were taken in preparation for your testimony here today, your rebuttal testimony that was filed with the commission. Is that correct?
Yes.
Sorry. So on August 2nd, you're taking pictures of attachments that you refer to in your testimony as Comporium attachments. Is that correct?
Correct.
Do you know the due date for Charter to provide its direct testimony in this case?
I do not.
Would it surprise you to know that that date was August 8th? I have no further questions, Madam Chair.
Thank you, Mr. Wright. AT&T?
Madam Chair, I had the same issue earlier as Mr. Wright did, so if anyone cannot hear me, please let me know. Mr. Lupino, you've been in the hearing room yesterday and today, is that correct?
Yes, sir.
And based on that, you've heard testimony from York to the effect that until recently, they had received no complaints about the clearance requirements that we're here to speak about today. You remember that testimony?
Yes, sir.
Do you have your rebuttal testimony in front of you?
I do.
Could you please go with me to page 4, lines 15 and 16?
Yes, sir.
And there you refer to South Carolina's recently adopted Broadband Accessibility Act, right?
On lines 15 and 16? Yes.
Okay. This is my last setup question, then I'm going to ask you my 2 real questions.
Okay.
Were you here this morning when York witness Mr. Basha and Chair Belser were having their conversation about the former limits on the commission's jurisdiction over electric cooperatives like York?
Yes.
In light of that testimony, do you have any reason to believe that Charter could have brought a complaint with this commission about those pole attachment clearance requirements prior to the Broadband Accessibility Act?
We really had no avenue to pursue that because before the BAA was in place, there was no recourse, in our opinion.
And it sounds like you've had some experience discussing these clearance issues with folks at York recently, right?
Yes, I was very surprised when I saw the 84-inch attachment because I've worked in 8 states and managed outside plant construction building in 8 states, and I've never seen an 84-inch attachment.
My question is this: based on your experience dealing with York about the clearance attachments that it's proposing here, do you have any reason to believe that had Charter complained about those clearances earlier, that York would have done anything about it?
I don't believe so.
Madam Chair, thank you. I have nothing further.
Thank you, Mr. Turner. Office of Regulatory Staff?
No questions from ORS. Thank you, Madam Chair.
Thank you, Mr. Huber. Commissioners? Commissioner Caston?
Well, Mr. Lupino,
Hello, sir.
you have the, as far as I know, the great honor of being the person that's the last one, I think,
Well, I hope so.
and the fortitude to do it. Thank you, sir.
I'm
for
here as
being
long
here.
as you need me.
I appreciate it. Well, I don't need you long at all, so.
Okay.
And I'm probably going to be plowing very similar ground.
Okay.
Want to make sure we all got it. Want to make sure I got it. Maybe everybody else already does. And you've been with Charter since 2017, I think you said.
That's correct.
Were you involved any with York Electric Cooperative during that time, or only since 2021?
Only since I took the construction position in April of 21.
So when you became, at what point did you become aware of that York Electric Cooperative has a standard that may be different than you had seen, but it went back quite a while?
It was around May or June of 2021, as I was new in the position, as we were starting to do preliminary work to start building the RDOF infrastructure. We had arranged meetings with multiple IOUs and co-ops to say, hey, this is the scope of our work. We know this is going to impose a great addition of work to you. We want to discuss it before we start so we can make plans to work together and try and, come to agreements on, the number of pole applications. And, if you needed any engineering assistance, we were offering engineering assistance with firms like McCall Thomas. We even offered, as a matter of fact, at the initial meeting with Craig Spencer and his team at York, when we discussed how much workload this was going to be for them, we had told them that we have contractors that have electrical arms to their business, such as in the contractor that we have doing the build in York's footprint is Quanta Communications, which owns Sumter Utilities, and Sumter Utilities is an electrical contractor that does work all over South Carolina for various electric companies. So we offered them that. We would pay and offer assistance if the workload for the make ready was too great for them to handle with their own people. And I'm sorry for the long-winded question or answer, but it was just at that time is when I became aware of that 84-inch when I started negotiations.
Did you find, I guess, the personnel you dealt with or had experience with, did you find them helpful, not helpful, obtuse? I mean,
no, as a matter of fact, and Mr. Bash just said it earlier that all the interactions with the Charter BAU team, were always pleasant and cordial. And all my dealings with Philip Quinn, Ben Jones, and Craig Spencer of York was always pleasant, and we were working together to try and work through the issues.
It's always best when you can do that, isn't it?
Yes.
And I've forgotten the attorney's name that just got up here and spoke, and I apologize. Yes. And I think he referred you to page 4 of your rebuttal, lines 15 through 16. And I was kind of looking at 13 through 16 actually earlier. I had it highlighted, so I assume I must have read that sometime. But you say that Charter presented the issue whether York may deny access to its poles based on construction requirements that exceed those of the National Electric Safety Code, consistent with South Carolina's recently adopted Broadband Accessibility Act, BAA. And I assume based on that, you're familiar with the BAA.
Not verbatim, but, you know, just what I've been shown and what I've looked at to where it seems to reference, you know, there should be non-discriminatory practices by the electric companies and allowing access to the poles.
Well, do you know what the basic purpose of the BAA is?
Yes, it's to provide broadband accessibility to all residents of the state at an affordable cost and quality broadband, I believe.
Can you show me where it says that? Because I missed that part. I saw the part where it said the unserved areas, but I didn't catch the part about all residents in the state. Now, I may be wrong. If I'm wrong, somebody point it out.
And I'm not like, you know, like I said, I don't know it verbatim, and
well, I don't either, so don't think that I do.
And there's a lot of legal language in there that is above my pay grade, but you know, it's basically an effort to assist companies in bringing broadband out to areas that do not have it. Unserved is definitely the key, and I know they're looking at doing underserved in the future.
I understand.
And Commissioner Caston, I would direct your attention to section 3000, subsection B, subsection 4. It says to facilitate access to broadband services at all locations in the state.
So are we saying that the BAA, are you telling me from that the BAA says that it is intended to serve to not the unserved areas, but every citizen in the state?
Wait a minute, Mr. Willoughby, this is question of the witness, please.
Oh, that's right. That's right.
I was just trying to help.
My understanding of it is to expand broadband to areas that do not have the availability for it now.
Good enough. That's your answer. So what areas does Charter intend? I think it was in your testimony that all the poles that you were concerned that were going to have to be replaced to meet, I guess, the existing standard. What area will Charter or Spectrum be serving that's going to require all those poles? Because it's what I've tried to figure out since yesterday. Where are we talking about serving? I haven't seen a map.
Okay. We have various locations across York's footprint in York County. We're placing about 180 to 200 miles of fiber. The broad estimate was to attach to almost 4,000 of York's poles, and a great number of those are 35-foot poles. And even in our initial meeting, their staking engineer, Philip Quinn, in looking at our map, had said there were specific areas where their poles were 35 foot and the majority would need to be replaced. So based on our calculations, we were figuring that with that 84-inch rule, we would have to replace probably 50 to 60% of York's poles, which is several $1 million.
Now, how many poles of those, to the best of your knowledge, would be in serving the unserved area?
The majority of those would be the unserved. There are, and I heard reference from the Telephone Association and from some of York's attorneys that we were on poles that already had fiber. And the reason that is when you're building a fiber infrastructure, you have to come from a main hub. You have to get that feeder fiber to a distribution point to where it distributes on the serving poles that are in the unserved areas. So yes, there are areas where we did attach, where there were other attachers, but that was feeder fiber that we're not providing services off of. That feeder fiber goes to where we are providing services. So the majority of that close to 4,000 number would be poles that would serve the unserved customers.
Okay, so the majority of those poles that need to be replaced will be replacing poles in areas that currently have no internet service.
That is correct.
Okay. And this isn't a trick question either. I asked it before, and I really wanted to ask it of Mr. Booth. To the best of your ability, can you tell me specifically where York Electric's requirements do not comply with the BAA?
Again, in all my experience in building in the telecom space or the communication space, it was always 40 inches below the neutral. By imposing that 84-inch rule is, in my opinion, and take away the attorneys, in my opinion, it's contradictory to where the BAA says you will allow access to these poles in accordance with the NESC.
Can you tell me show me where it says that specific?
I don't have that. One second. This is too many papers for a construction guy.
And I'll admit, there's a lot of lines in that thing too, and they got a lot of paragraphs that don't have enough spaces between them. But
the express language of the BAA requires that electric cooperatives shall provide communications companies with non-discriminatory access, and that access includes the right to non-discriminatory use of the poles to the extent not prohibited by the NESC. And again, I'm not a lawyer, but to my understanding, it is, to me, that says we follow, you can't discriminate access to the poles as long as we are abiding by the NESC standards.
just for my edification, can you give me the
I'm sorry.
specific?
That is the 58-9-3030A.
3030A.
Yes.
Okay, so are you reading where it says access?
Yes, sir.
Access includes the right to non-discriminatory use of all easements and rights of way to all poles, ducts, conduits, to the extent not prohibited by the National Electric Safety Code and similar. Is that the section you were referring to?
Yes, sir.
So you interpret that section as that they mention National Electric Safety Code, and that means everything in that paragraph or on that sentence or whatever. Is that your interpretation?
Yes, my interpretation is following the National Electric Safety Code. That, to me, that the BAA supersedes their requirement of the 84-inch, which was imposed before the BAA was adopted. In other words, we had no choice before the BAA but to enter in into that agreement, because had we contested that, they would have said too bad.
And, Corey, so am I understanding you're saying that the existing standard is the existing standard, but you're saying, or I guess Charter is saying via you, that but for this interpretation, that the National Electric Safety Code applies to all that stuff, this supersedes their longstanding standard. Is that what I'm hearing?
Yes, and that's what we were trying to negotiate into the new pole attachment agreement that we started negotiations with York. Just to recognize that language.
But if this doesn't apply to all that, then what does that mean?
Then it would mean that we would be forced to adhere to the 84 inches. And we would either have to weigh the cost of, do we rebuild York's infrastructure for them at our cost and at the cost of the federal dollars that we received? And by doing that, that would allow us to reach less people because it's more expensive. And if we have to spend those dollars to do that exorbitant rebuild of their network, we're not able to use those funds to get as far out. And it also delays the deployment of that all of that make-ready work takes time. And then what we ended up doing is we did end up in a lot of this area going buried, which is more costly. I haven't done a total cost analysis, but I believe it will most likely be less than rebuilding all of those poles that I had mentioned, half of that 50 to 60%, and it has delayed our build out.
You ought to put a 36-inch line through granite, but I understand it is more expensive most likely. Well, so you've said today that it is Charter's intent, and I guess the majority of the poles that will need to be replaced will be because Charter intends to serve the non-served area. And I'm assuming, and correct me if I'm wrong, is the same non-served area that York Electric is going to be serving, that 4,000 to 5,000 customers. Is that true?
I did not do a drill down to a street by street analysis, but when I overlaid the map off of the York website to the map of our RDOF build, I'd say we overlap probably 70 to 80%. So again, not unless I did a street by street analysis, I don't know exactly how much of an area we are overlapping, but there are a lot of areas that yes, we would both be building in the same areas. But when we accepted the RDOF funds, we have no choice now. We would be in violation of that contract for that funding if we did not build into these areas. So regardless if somebody gets there before us, we still have to fulfill that contractual obligation and build the RDOF area.
So York did not accept any funds and they're funding this. But because Charter accepted the funds to do this, they're going to run parallel lines in the same area on the same poles?
In some areas, yes.
Well, I mean, it's either the unserved area or it's not. I mean,
yes, but we're not 100% in the same footprint. Again, like I said, I just did a very high-level analysis of both maps.
See, I was thinking the BAA had something talking about efficiency or anything.
We had bid for this funding in 2019, and Mr. Basha even said they had put in a bid for it, but they had opted out, and Complainant had the right to put in for that as well. We put in for it. We proved that we had the best business case for it, and we were chosen to build it.
Okay. Well, I appreciate it. I have no more, so as far as I'm concerned, you can go home.
Thank you, sir.
Yes, sir.
Commissioners, further questions? Commissioner Carolee Williams?
Thank you, Chair Belser. Hello, Mr. Lupino. Good to
there.
meet you, despite the hour. I'm going to start with what is probably an easy question. What does it mean when you talk about the tags indicating Comporium's name were on the fiber?
In most cases, when a communications company places a cable, most usually in a fiber situation, and if it's a fiber cable, they'll put an identification tag on it. It's an orange tag, and it has, caution fiber optic cable, and it usually has the company name of whose fiber that is on that tag.
Given the images we were looking at, is it true that those were in the air, hanging, associated with wires?
I believe some of those had some orange tags, but you can't make out what's on those tags.
Okay. You were testifying a few minutes ago from the BAA, a phrase that says, access includes the right to non-discriminatory use of all easements, rights of way. I'm in 3030A. And I'm in the second half of that. Access includes the right to non-discriminatory use of all easements and rights of way and to all poles, ducts, conduits to the extent not prohibited by the NESC. Tell me what the phrase "to the extent not prohibited by the NESC" means to you as it relates to the 84 inches and the 18 feet.
Again, I am not an attorney, so if my interpretation is incorrect, I see that as the predominant rule on accessing any of their infrastructure is, as long as you follow that NESC code, that you're allowed under this act to have access to those items.
So are you testifying that they're not following the NESC code right now with those two standards?
With that they're imposing on us, the 84 inch and
right.
15 and a half. Yes, I feel that, again, that's discriminatory because it's not what the NESC says.
But are you suggesting that those standards are prohibited?
Yes,
by NESC?
I believe so.
Okay. I have gotten very confused about, and you can only help me with half of this, about the areas. And as Commissioner Caston mentioned, we're both, I think we're both map people and would wish that there had been something submitted, and there may be a late file request coming. But I am confused about the locations of where you all have been awarded, and I believe those are by a census tract or block.
Census blocks, yes.
And that only one entity was awarded those funds for that area.
Correct.
Is that true?
Correct.
Okay. Where the confusion comes in for me is the difference between those areas where you are trying to deploy as fast as you can to serve those areas and the 4,800 to 5,000 households that York is working in, not as an affiliate, maybe the word was partnership with Comporium, but can you try again to describe where you all are working to deploy versus those unserved approximately 5,000 households where there is a partnership to install? Are those conflicting based on the mapping that you've done?
If I would have to know, I'd have to look at right down to the street level pretty much to know, if we are totally overlapping. I'm sure we're overlapping some of the 4,000 to 5,000 that Mr. Basha had referred to. I don't know that we're overlapping 100% of those. I just don't know that without doing a real close comparison of both maps.
Are you aware if there's any testimony related to the census tracts that Charter was awarded?
I don't know that the census blocks have come up in this hearing at all.
Okay. Is it appropriate for me to ask for a map that would show the census blocks that Charter was awarded in the York Electric territory as a late filed exhibit.
Madam Chair, I have a concern about this, and I certainly understand why y'all are interested and why you're asking the questions, but it ought to tell you something that this is coming up, this issue is coming up, not in any pre-file testimony. There was no pre-file testimony about this. And it's coming up when y'all are asking questions of Mr. Lupino, who was a rebuttal witness. This is the kind of issue that had Charter, who was notified and informed and in fact given a summary of the terms of the agreement between York and Comporium, had Charter availed itself of the provision under 3030C to go through the process of executing a non-disclosure agreement, getting a copy of the contract, working through the ORS process of ORS doing an investigation, and then filing a complaint under those terms, because the complaint is if after that investigation, Charter believes that the arrangement between York and Comporium is harmful to competition, then a complaint can be filed. And those issues would have been presented to y'all, and you would have been told, and you wouldn't be getting this at the time you're getting it, which is at the very last witness. And so I think we just don't think it's fair to put that in and have it become part of the record for a decision on the issues that were actually presented to y'all, when it could have, and if they wanted to pursue that, they should have pursued it under the other provision. So.
And Madam Chair, if I could respond briefly. First of all, we'll be happy to provide you that overlay map to show you where those areas are in our RDOF. So we'll be happy to do that. But in all due respect to my good friend, Mr. Ellerby, we all stood in this courtroom on July the 11th with us having a motion to strike everything about all of the additional information that they wanted to put into this record. And we wanted to focus this hearing on one simple legal issue. That is the question of whether or not the NASC, whether there could be a variance in construction standards from the NASC. And Mr. Ellerby and all of his cohorts stood up and argued that no, we need the ability to bring in additional evidence. And y'all agreed with them. You issued an order that says they could enlarge the issues in this hearing. And now that the issues have been enlarged at their request, they all of a sudden raise their hands and fling and flail and say, by George, you've picked on something that we really didn't want you to get into, and now we want to object. I just think that's absurd. They opened it up. They're stuck with the consequences. We still contend, as I said in my opening presentation, that there is a single legal issue for this commission to decide, notwithstanding all of the additional information that they put in. They've tried to sullen Charter with bills that they say were not paid, and we've brought in evidence to demonstrate some of the clarity of that. The upshot of all that is, if you want the information, we'll be happy to provide you with an overlay map to show you where there is overbuild by Comporium on top of the RDOF awarded area that Charter was awarded.
Madam Chair, I'd like to respond to Mr. Willoughby's characterization of the argument we made in response to their motion to strike. They filed a petition to initiate this proceeding under Section 3030A for just, reasonable, and non-discriminatory terms and conditions. That's the caption of the proceeding. They made the argument that it was a pure question of law. Our view was, when you're talking about whether something is just and reasonable and non-discriminatory, that it is appropriate to have testimony that explains the facts and circumstances that caused the company to adopt York Electric Cooperative to adopt the clearances that it adopted, that it has adopted back in 2002, 2004. We thought that was the issue that they had presented. Our way of responding to that issue was to explain the circumstances and why it was just and reasonable and non-discriminatory. We wanted you to know that every other provider had the same terms and conditions, the same requirements. We wanted you to know what the facts and circumstances were giving rise to that, and then that has been presented. And that, in our view, and that was the argument we made to y'all, was that type of evidence, and we put it in our pleading, and they moved to strike it, that type of evidence was necessary for us to respond to their petition that was filed under 3030A. No point in there, when they filed their testimony, there wasn't one word about the York Comporium Agreement. They put it in their rebuttal. They've now developed it with Mr. Lupino's responses to y'all's questions. I think it's an issue that is not framed by this proceeding, and they had a mechanism to do that. They chose not to pursue it. We don't think that they can get into that. So, thank you.
In all due respect, let me add this. When we filed our testimony, our initial testimony, we were again faithful to the argument we had made to the commission. We said this petition was a single issue on in the petition, and on July the 11th, when we made the argument, we felt it would have been duplicitous of us if we had all of a sudden then expanded what we had very carefully articulated in all of our arguments. So we stayed faithful. And if they had just responded to our direct testimony, we would have said nothing more but provided rebuttal to whatever the issue was that they may have said. But they came in and said that their conduct was non-discriminatory, that everything they were doing did not discriminate against anything that Charter wanted, that their policy was non-discriminatory. We then had a duty to respond to that if we wanted to protect our position, and we did that through our rebuttal testimony. So this argument about that we've had an opportunity to do this and we haven't taken advantage of it, trying to, again, cast aspersion on our actions is just absolutely wrong and not true.
Thank you, gentlemen.
Madam Chair, I'm sorry.
Who's talking? Mr. Wright?
Yes, ma'am. Could I just add briefly to that? I feel a little caught in the middle here, despite sort of some assumptions, I think, by Mr. Willoughby about our position in this. But the SCTC was fine with keeping this proceeding to a narrow proceeding as it was originally styled. It was actually Mr. Werner in his reply comments in that July hearing where he changed the nature of this hearing from originally, can you exceed the NESC requirements, to an issue about make-ready costs. And because he said, oh, you can exceed them, but you got to pay, but York has to pay for it. And that was a different question. That expanded the proceeding at that point in time. The electric co-ops wanted to talk about just and reasonable under subsection A. That's a fight between these two that we're not part of. But the thing that is troubling to me is all this discussion about the subsection C and the third-party agreement, because there's a process to follow. It could have been followed here. We know the petitioners knew about that process. It was York that we've seen in their testimony that told them about that process. They've not availed themselves of it, but tried to make that agreement seem like some sort of boogeyman, and that I object to. If they wanted to go through that process, they should have followed it, and this would have been an entirely different proceeding than the one they originally styled. Thank you.
And let me make this clear too, and I think Mr. Turner has done this several times on behalf of AT&T. We have absolutely not waived, Charter has not waived any right to make further inquiry at another time and on another day about the Comporium agreement and its effectiveness, or whether it discriminates, all of those things.
Madam.
So we have not waived those issues. So I don't want them casting that rock, because I think that's what they're trying to do, is argue that we've somehow waived that. Again, we've been faithful to the petition that we filed. We think you've got a single legal issue, and that legal issue is to determine under the language of the Act, the public policy of the state, this single legal issue is whether or not they can impose a construction standard that exceeds the requirements of the National Electrical Safety.
We're getting beyond the objection, okay? Do I get to talk now? Okay. Commissioner wants the map. We're not talking about the contract, the underlying contract. She wants to see the map. So we'll reserve a late filed exhibit for just the map of the service area. Thank you.
Thank you, Madam Chair.
Hearing exhibit number 10.
This is probably the inappropriate time to ask for this, so I expect to be told when I should ask, but I'm also interested in a late filed exhibit that shows the territory that has been described as the area where the 4,800 to 5,000 households are being served by York Electric, if that's appropriate.
Is that part of that contract?
It's not part of the contract, and apparently it is publicly available. So with the same concern, I'm not waiving anything.
Nobody's
either.
waiving any rights or remedies
Right.
or thank you for adding that, but.
Okay, York isn't, my colleague asked me to make it clear that it's where York has extended the fiber. York is not providing the broadband service.
York's fiber.
Right.
Okay.
Thank you.
All right, so you're going to provide, yours is going to be 11, late filed 11, and you're going to provide what's publicly available. Mr. Willoughby, the overlay that Mr. Lupino talked about is number 10.
Yes, ma'am.
Thank you.
Thank you, Madam Chair and parties. No further questions.
Commissioners, anything further?
Madam Chair,
Commissioner Irvin?
I have a couple of follow-up questions for the witness. Cross, or Commissioner questions. May I proceed?
Oh, I apologize, Commissioner Irvin. Please go ahead.
Thank you. In your earlier testimony, you indicated that Charter Spectrum has had to lay cable underground at a higher expense than had you been able to attach to the York infrastructure or poles. Is that my understanding?
Yes, sir, that's correct.
And has that resulted in harm to your employer in the sense that they've had to expend additional sums over and above what you contend they could have avoided had you been given access to the poles under the national code?
I wouldn't say harm. It did cause more expense. It did cause a delay because we had to re-engineer. When you go from aerial to underground, you have to re-engineer. Then we had to apply for South Carolina DOT permits. Those take time, so it did significantly delay the deployment.
Have you completed the underground deployment, or has that decision been made yet?
No, originally the build was to go through 2022 and 2023. We are a little bit behind our schedule for 2022, so we will be building into 2023 as well.
Okay. So to the extent there are additional costs, they're ongoing. Is that my understanding?
That is correct.
Okay. And one thing that, you know, I'm curious about, I've heard it talk about maybe overlapping territories and census blocks and that kind of thing. But I was thinking back of the very first witness that we had, who was a resident out there, that talked about his wife having cancer, and I believe it was the bank allowed her to work virtually from home if she had broadband access, and of course their child was in public school and it allowed their child access to the school curriculum. That caused me to think, you know, when you talk about an unserved area, isn't it true that if one person in South Carolina is unserved, that is in contradiction to the purpose of the Broadband Accessibility Act? Isn't that true?
It may be an interpretation of that, but from what we discussed a few minutes ago, I would say yes.
Because as you cited earlier from the statute, I think someone was kind enough to give you the line number and the paragraph number. The Broadband Accessibility Act says that we have to serve all areas of the state, regardless. Isn't that your understanding of the act?
I understand it as we need to be given the ability to serve those areas, yes.
Right. And that's what you're attempting to do and have been attempting to do throughout this process. Is that right?
Yes, sir.
Right. Thank you. No further questions.
Thank you, Commissioner Urban. Commissioners? Redirect?
Just briefly, Madam Chair. Mr. Lupino, I think you've indicated that for the RDOF award that Charter received, that you have an obligation to serve those areas. Is that correct?
Yes, once we accepted that award, we had a timeline to reject any census blocks that we did not want to build. That time has passed, so we do have to build all of the census blocks we had agreed to and were awarded.
And when you do your plans for any construction, how does those plans break down between aerial overhead construction versus underground?
In the preliminary phases across the state, we were estimating about an 80% aerial, 20% buried build, but right now in the York footprint, we're flipped that. We're about 20% aerial and 80% buried.
And why do you try to use 80% aerial?
It's less expensive. It's quicker. Maintenance after it's placed, it's harder to troubleshoot buried plant than it is aerial plant. There's several reasons, but those are the main ones.
So it's cost and time.
Yes.
And when costs increase, does the ability to serve a broader customer base diminish?
Yes, that's correct.
Same amount of dollars go to fewer customers.
Yes, and just to note, the federal money that we were allocated, Charter is contributing an additional $3 to $4 for every dollar that we receive from the FCC out of our own capital funding.
Is that a requirement?
No.
Now, you were asked about the Broadband Accessibility Act, and you mentioned Section 3030A. Do you also have available to you Section 3030D2? It's on that sheet that you have.
Yes, sir.
No, the sheet that you had, go back to the sheet that you had.
Oh. Sorry.
Do you have that in front of you now?
Yes, sir. Thank you.
Would you read section 3030 D2?
Starting at,
Read all of D2.
D2. A communications service provider that has attached or applied to attached facilities on electric cooperative infrastructure and the electric cooperative must cooperate with the owner of the pole and all attaching entities in good faith to fully comply with National Electric Safety Code requirements for electric infrastructure attachments.
Now, I think in your information, Mr. Lapino, you indicated, I think, that you were a lineman for a number of years. Is that correct?
Yes, sir.
How long were you a lineman?
I think this is beyond the scope of redirect, Madam Chair, and I object to it.
I do think.
I'm sorry, repeat the question, please.
Yeah. You were a lineman at one time early in your career.
For about 8 years, yes.
Did you work in the communications worker safety zone?
Yes, I did.
I believe that was covered, Mr. Ellerby.
Well, it was covered in his summary of his direct testimony. I don't believe that, I didn't think it came up on cross or commissioner questions.
Okay.
I thought it came out on, when he was giving his summary.
Someone asked him, had he worked in areas that, and what had he observed in the areas that
They did do that. They did do that.
And when you were working, and even since then, because you've been in the construction phase virtually your whole career, is that correct?
Yes, sir. 30 plus years.
And how many states did you say you've served in?
8, from New York to Florida.
And what have you seen to be the standard for the communication worker safety zone during those 8 states in all of your career?
As I stated, this was the first time I'd ever seen an 84-inch requirement. It was always 40 inches below the neutral.
And how about for the mid-span clearance?
It was the 15 and a half feet. And I will say that Charter does, when there is room on the poles, we do instruct our contractors and any in-house employees that if we have space, we do 18 feet over any roadways, whether it's a state road, a county road. But if we don't have space on the poles, then we make sure that it's at least the minimum 15 and a half feet.
Thank you very much. Those are all my questions, Madam Chair.
Limited recross?
None, Madam Chair.
Okay, thank you. Commissioners? Okay. Mr. Lapino, thank you for your testimony today.
Thank you all
You
very
are
much.
you may step down. Is there anything else?
That concludes our testimony, Madam Chair.
In this, Ms. Moser had to leave, and I will ask her to email y'all with dates on proposed orders, briefs, whatever we want to do. We do have a timeline on having to make a decision. I think we'll get with the court reporter and she'll send out dates.
Have y'all calculated it's 6 or 180 days from, I think, the day the petition was filed, which was May 19th. I've been assuming November 19th, but
I was thinking it was November 16th or somewhere in there, but it was somewhere in that.
Okay, I'm
Does
sure.
anybody dispute that?
I'm sure Ms. Moser can clarify that for us.
I knew it was sometime in November, Mr. Ellerby, is what I had on my radar.
Chair,
Commissioner Urban?
for the record, do we set deadlines on the late filed exhibits just so that we'll have a record completed in a timely fashion? Did we do that?
We did not, but we will. We've got number 7 coming from Mr. Basha, and then 2 from Mr. Lapino. Can we have those by midweek next week? Does that work?
I think we got one also. Number 11 is
11.
ours also.
Okay,
Yeah,
I'm
I
sorry.
think-
It
yeah, I
was
think that-
it was through the witness. That's
Yeah.
what I was looking at.
I think, Madam Chair, we only have one, and that's number 10.
There
is the
was
overlay.
a late filed exhibit on the number of poles York has to alter in connection with the fiber project.
I think that was
That was-
7.
I'm sorry, number 7. That was requested by Commissioner Justin Williams. Is that y'all?
Yes, we've that's our responsibility.
Okay. Do y'all think we can have those by next Wednesday?
We have 10 days, Your Honor. Say that today.
You want 10 days from today? That'll be probably, what, Friday of next week?
Yes, ma'am.
I don't know the date. The 8th, maybe? Does that sound right? No, the
We
7th.
can do that. We can
Okay.
do that. Madam
Friday
Chair.
week. I think it's the 7th. Thank y'all very much. We appreciate everybody's professionalism, their attendance, their forthrightness.
And thank everyone for your
So-
indulgence.
That works
Appreciate
both ways,
being with
Mr. Willoughby. Thank y'all very much. Everybody have safe travels and keep away from the storm that seems to be heading our way. I do see where they've removed the cow from the stand in West Ashley, so that's always my weather vane. With that, we're adjourned.